I'm calling to order this hearing. This is a public hearing of the Committee of the Whole of the Council of the District of Columbia. I'm Phil Mendelson, Chair of the Council and Chair of the Committee of the Whole. Today is Friday, July 10th, 2026. The time is 10:22 in the morning. We're in room 412 of the Johnny Wilson Building. This hearing is being recorded and will be available on the council's website, which is www.dccouncil.gov. The subject of this hearing is, if I'm counting correctly, 10 bills related to real property taxation. The bills are, and I'm going to take a few minutes to describe all this. Bill 26-252, the Real Property Assessment and Appeals Schedule Revision Act of 2025, was introduced last year. In fact, it was introduced on May 19th of 2025 by then Councilmember Kenyon McDuffie. The stated purpose of this bill is to amend Title 47 of the DC Code to provide extended assessment notice and first-level appeal dates for large valued real properties, to revise which real properties are required to file income and expense information with the Office of Tax and Revenue, to require large valued real property owners to file electronically when directed to by the Office of Tax and Revenue, and to allow the Office of Tax and Revenue to send electronic appeal responses to the property owner. The second bill is Bill 26-360, entitled the Senior Tax Aggregation Amendment Act of 2025. This bill was introduced on September 22nd last year by council members Janice Lewis-George, Anita Bonds, Robert White, Charles Allen, Matt Truman, and Brooke Pinto. The stated purpose of this bill is to amend, again, Title 47, to allow for the aggregation of the ownership interests of two or more individuals over the age of 65 to meet the 50% ownership requirement to qualify for the reduced property tax liability program. The third bill is Bill 26-476, entitled Disabled Veterans Complete Property Tax Exemption Amendment Act of 2025. This bill was introduced last November 14th by Councilmembers Brooke Pinto and Janice Lewis-George. The stated purpose of this bill is to amend Title 47 to exempt 100% of the taxation of real property for owners who are veterans classified as having a total and permanent disability or the surviving spouse of a disabled veteran. The next bill is Bill 26-484, entitled the Fairness and Accuracy in Real Property Tax Assessments Amendment Act of 2025. This bill was introduced on November 17th, 2025 by Councilmember Brooke Pinto, and its purpose is to amend DC Official Code Title 21 to extend the applicability of letters of authorization for purposes of tax appeals, and also to amend Title 47 to eliminate the 5% rule limiting assessment relief. The next bill is Bill 26-564, entitled Food and Friends Property Tax Exemption Amendment Act of 2026. This bill was introduced by myself and Councilmember Zachary Parker on January 2nd of this year, and its stated purpose is to amend Title 47 of the District of Columbia Official Code to exempt from real property tax the Food and Friends property located at 219 Riggs Road Northeast. The next bill is Bill 26-641, entitled the Archdiocese of Washington Parish Real Property Deed Recordation and Transfer Tax Exemption Amendment Act of 2026. The purpose of this bill is, the stated purpose is to amend, again, Title 47. That should not be a surprise with these bills. To provide real property, deed recordation, and deed transfer tax exemptions for properties held under the ownership of the Roman Catholic Archbishop of Washington and his successors in office, a corporation sole, or the respective parishes of the Archdiocese of Washington. The next bill is Bill 26-686, entitled the Alpha Omega Social Action and Scholarship Foundation Real Property Tax Exemption Act of 2026, which was introduced on May 6th of this year by myself. And the stated purpose of this bill is to amend Title 47 to exempt from real property taxation the Alpha Omega Social Action and Scholarship Foundation property located at 1231 Harvard Street Northwest. And possibly the last bill on this list is Bill 26-700, entitled the Reservoir District Tax Exemption Amendment Act of 2026. This was introduced on June 3rd of 2026, so a little over a month ago, by Councilmember Zachary Parker. And the stated purpose of this bill is to amend Title 47 to designate the property, doesn't say what property in the hearing notice, over with the former McMillan Reservoir site, sand filtration site location, to designate the property as affordable housing for which fair market rents, as calculated by the U.S. Department of Housing and Urban Development, apply. So those are all the bills. The witness list is in slightly different order than those bills, and it's our practice that government witnesses, and there are 3 from the Office of the Chief Financial Officer who will be at the end of the list, and that's where we will find out issues that we may have to deal with these bills. The record in this matter will be open for 2 weeks. That is, the record will close at 5 p.m. on Friday, July 24th. What does that mean? We're a political body. If somebody sends us comments in August, we'll look at them and consider them. But if you want them in the record, they have to be filed within 2 weeks. That is by 5 p.m. Friday, July 24th. So I'm going to proceed with witnesses, and the first will be Carrie Stolfus, who is CEO at Food and Friends, and this concerns Bill 26-564. I'm never quite sure how to pronounce your last name.
Stoltzfus. You did great.
Yeah, I know I didn't, but thank you.
It doesn't rhyme with anything, so I
Okay.
can't help you. Good morning, Chair Mendelson. I'm Carrie Stoltzfus, CEO of Food and Friends, an organization that provides medically tailored meals and nutrition counseling to individuals diagnosed with serious health issues and their caregivers and dependents across the metro region. In FY25, we provided nearly 1,055,000 meals to 3,039 district residents, all of whom were facing diagnoses of cancer, heart and kidney failure, HIV/AIDS, and many other illnesses. I am here today to testify on behalf of a permanent property tax exemption for Food and Friends, 160564, the Food and Friends Property Tax Exemption Amendment Act of 2026, which was introduced by yourself and Councilmember Zachary Parker. Food and Friends has operated from 219 Riggs Road Northeast on land owned by our organization since 2004. When we purchased the property, there was a billboard in the corner of our lot. We leased the billboard to Clear Channel, and in March 2006, DC's Real Property Assessment Division determined that since the billboard provided us with income unrelated to our mission, we would pay property tax on 3% of our property, the estimate of the amount of our land that was used for the billboard and not for the mission of Food and Friends. In March 2023, we ended our agreement with Clear Channel and removed the billboard. In 2025, we applied for exemption for the property tax on 3% of our land, as 100% was now used in service of our mission. It is notable that if we had to pay our 2026 estimated annual property tax, the amount would be $247,511.94. This is the cost of approximately 27,810 meals that instead go to vulnerable district residents. The purpose of my testimony today is to support Bill 16-564 and request that the 2 parcels of Food and Friends land that have been viewed differently for tax purposes, the 97% exempted from property tax since we began operations at 219 Riggs Road in 2004, and the 3% previously assigned to the billboard, be joined into a 100% property tax exemption. We support this legislation because we believe that Food and Friends should receive a permanent tax exemption so long as the property is owned by Food and Friends, and provided that Food and Friends or any lessee of the property continue to use the property to provide charitable food distribution. Mr. Chairman, I would like to raise one final point. The temporary legislation that includes our property tax exemption is set to expire on September 25th. Therefore, if the permanent bill we are discussing today is passed in September, it will also need to be enacted on an emergency and temporary basis to ensure continuity of the exemption while the permanent legislation takes effect. Food and Friends is proud to serve the region from our home in the District of Columbia, and I'm grateful for the support and partnership we've received from the DC Council and the DC Department of Health. Thank you.
Thank you. Give me a second. The exemption that you've had was for 97% of the property, and the exemption that the council continued is for 97% of the property,
Yes,
and this bill would be for 100%.
yes. Since we no longer have the billboard and we're no longer receiving unrelated business income, that's our request.
Got it. I don't have any other questions for you.
Thank you.
Thank you very much. Turning to Bill 26-641, I have a lot of witnesses here, as in 6. I don't know if they're all present. Mary Rhodes, Senior Counsel with the Archdiocese. Virtual. Jeff Gelman, Partner at Saul Ewing. Reverend Daniel Carson, Pastor and former Vicar and moderator of the Curia St. Peter Catholic Church. Virtual. Reverend Cornelius Ajigu, pastor of Our Lady of Perpetual Help Catholic Church. Virtual. Reverend Charles Antonicelli, judicial vicar and pastor, Archdiocese of Washington. We don't see him. And Reverend William Gurney, pastor, St. Joseph's Capitol Hill Church. Not online. So it looks like we have the first 4 all virtual. We'll begin with Ms. Rhodes.
Good morning, Chairman Mendelson and members of the Committee of the Whole. Are you able to hear me okay?
Yes, can't see you, but can hear you.
Yeah, and I apologize. I had my camera on and now it's not working. So I'll do the best I can. And
Never blame the technology. That's just so wrong because it can't defend itself. But
mea culpa then, mea culpa. Thank you. Oh, good morning again. My name is Mary Rhodes. I'm Senior Counsel for the Archdiocese of Washington. I thank you for the opportunity to testify today on Bill 26-641. As this bill moves forward, I ask you to reaffirm that both this bill and the temporary bill which preceded it were intended to ensure Catholic parishes may record supplemental deeds to retitle their parish properties so that DC property records accurately reflect that the parishes are the long-standing property owners. As Councilmember Parker adeptly stated in his letter introducing this bill, and Chairman Mendelson likewise recognized in the emergency resolution for the related emergency bill, supplemental deeds are appropriate here because the parishes already beneficially and equitably own these properties. The parishes purchase them with their own funds, they occupy them, maintain them, and pay expenses. Numerous DC public records, including those in the Office of Tax and Revenue's own database and files, already and for many years have reflected the parishes as the owners. The properties are held under the record ownership of the Archdiocese only because historic legal restrictions prevented parishes from holding title in their own names. The supplemental deeds we seek to record would serve merely to confirm the parish's longstanding ownership rights and modify public records accordingly. This is not a situation where the Archdiocese is transferring its own property to parishes. This is not even a transfer of property from one entity to another. It is simply a correction of record ownership to ensure that record ownership aligns with existing beneficial ownership. This is exactly the type of situation where, even prior to this legislation, DC law makes clear that supplemental deeds are warranted and appropriate. Unfortunately, and despite the council unanimously passing emergency and temporary legislation confirming that Catholic parishes may retitle their properties in their own names through supplemental deeds, when we tried recording a supplemental deed, OTR instructed the recorder of deeds to reject it. OTR claimed that the legislative language, which clearly states that the properties, quote, may be transferred through supplemental deeds, end quote, is inapplicable, and that all references to supplemental deeds must be removed. This contradictory interpretation presents an issue because the legislation before you today contains the same language as the emergency and temporary legislation. The legislation's very intent is to ensure supplemental deeds could be recorded to confirm the parish's existing ownership and appropriate tax exemptions. OTR maintains that the Archdiocese owns these properties and that the supplemental deeds would transfer the properties to new parish entities that never existed before the year 2023, when our parish is incorporated. While the parishes did incorporate in 2023, they existed long before that. Nearly all 38 parishes in DC predate the existence of the Archdiocese, with some dating back to the 1700s. The fact that the parishes took on a different legal form by incorporating, done in part because they faced increasing difficulties with DC governmental offices when they were unincorporated, does not erase the parish's historical existence. In fact, the parish's 2023 incorporation documents clearly stated that the parishes were already existing entities incorporating for the purpose of documenting their civil status. We appreciate that OTR is now indicating a possible willingness to resolve this issue. We respectfully ask the council work with us to ensure that the final bill includes language that properly allows for the recordation of supplemental deeds, recognizing the parish's longstanding ownership rights. We request the council reaffirm the legislative intent to ensure accuracy in the public records, fairness to the parishes that purchase these properties, consistency with DC law, and continuing recognition of these tax-exempt parish properties. I thank you for your time, and I am happy to answer any questions.
Thank you, Ms. Rhodes. I will have some questions for you. Jeff Gelman. You're muted.
Thank you. Good day, Chairman Mendelson and members of the Committee of the Whole. I'm Jeff Gelman, a partner of Saw Ewing, and I've been practicing real estate law in the district for approximately 40 years and have served in various real estate industry leadership positions. My practice regularly involves real property taxation. I was engaged to assist the Archdiocese in transferring approximately 300 parish properties in 5 counties in Maryland and nearly 100 properties owned by approximately 38 parishes in the districts. The facts and law were clear in both the state of Maryland and the District of Columbia. We anticipated that the effort to transfer legal title to the beneficiary owners would be relatively smooth given existing law. The state of Maryland and the clerk's office in the 5 Maryland counties, after raising thoughtful, reasonable questions and receiving satisfactory answers, allowed for the recording of the supplemental confirmatory deeds without the imposition of transfer and recordation taxes. Our experience with the record of deeds in the tax office was considerably different. Rather than receiving understandable questions and being afforded a reasonable opportunity to respond through discussion, we received conclusory statements of rejection without any particular degree of detail, either factually or legally. After our written attempts for reconsideration, we received a letter citing to a number of court decisions as a rationale for the ROD's position. After reviewing these court decisions, none of which were factually or legally relevant, we presented a letter dated March 5th, 2024, a copy of which is attached to my testimony, which distinguishes and refutes the relevancy of each and every one of these court cases. Nevertheless, when the parishes sought to have legal title transferred from the Archdiocese to each parish, the effort to do so was blocked by the Recorder of Deeds. The council has stepped up to right this wrong with the passage of this legislation. Unfortunately, when the Archdiocese attempted to record a single supplemental confirmatory deed, it was again rejected, And the recorder of deeds stated, the deeds conveying these properties from the archbishop to the parish are not supplemental deeds for recordation and transfer tax purposes. I think the recorder of deeds is misrelying on one particular court case, the Columbia Realty court case, where there is a quoted phrase that you are not to use a supplemental deed between separate and distinct entities. But the facts in that case were 100% different. There was a single trust with beneficiaries, and they were conveying in fee simple to a brand new limited partnership that never existed before for consideration, which takes it outside the definition of supplemental deeds. The ownership was not identical. And so it was just a situation that was entirely irrelevant from a factual standpoint, but a portion of the court's ruling was taken out of context and just regularly repeated to us as the rationale. So that decision actually supports us, but it contrasted their facts with our facts, saying it's our facts that warrant a supplemental deed, not those in Columbia Realty case. And so we proceeded with the supplemental deed because we have regulations, longstanding district that calls for a supplemental deed called the naked title deed regulations. The definition of supplemental deed fits our facts. And we have a court case, the tax division of the Superior Court, the Felder court decision, that's exactly on point, that ruled that a supplemental deed is appropriate here. And so we are, again, at the point where the existing language will be resisted by the recorder of deeds, and we've recommended some additional verbiage at the end of my testimony to be included in the permanent legislation. And I thank you for the opportunity to testify, and I welcome any questions you may have.
Thank you. Thank you, Mr. Gelman. Reverend Carson?
Good morning.
Good morning.
I am Father Daniel Carson, pastor of St. Peter Catholic Church and our pre-K through 8 school. I support Bill 26641. We are a good neighbor in the District of Columbia, located just a few blocks southeast of the Capitol building. Among many ways we provide outreach to the community, I highlight our St. Vincent de Paul ministry, which provides one-time financial assistance to residents in the community in emergency help, such as loss of job and needs help paying the rent or mortgage, or illness needing help with medical bills, or falling behind on utility bills, or help to buy food. In addition to our outreach and solidarity with people on the margins and other social justice initiatives, you may remember that we provided hands-on assistance to newcomer migrants who were transported to the district from the other states in 2022 and brought to our church hall where we provided pastoral care. Before serving at St. Peter's, I was Vicar General and moderator of the Curia of the Archdiocese of Washington, a kind of chief of staff overseeing day-to-day and long-term operations of the Archdiocese, during a time when the incorporation of parishes and retitling of parish properties was starting to come to fruition after many years of research and consideration. In these roles, I became quite familiar with how parish properties were purchased and operated. Most parishes in DC were established and held their properties prior to the creation of the Archdiocese itself in 1939, with some DC parishes dating back to the 1700s. Although these parish properties were technically titled under the name of the Archbishop as a corporation sole, because Catholic parishes could not hold legal title in their own names under local law. In real life, parish buildings and land are and have been occupied, operated, maintained, and paid for by the respective parish communities and pastors, with the initial acquisition of the properties coming from fundraising and donations of parishioners and pastors. In actuality, then, the parishes are the real owners of their properties. It is only right and just that they be recognized in the public records as such. Together with my fellow pastors, I'm grateful to the Council for the passage of the emergency and temporary bills, which both recognize the properties of St. Peter's and other parishes have been and should continue to be tax exempt, and also provide for the recording of supplemental confirmatory deeds to parish corporations to reflect the long-time reality of the parish's actual ownership. Unfortunately, DC parishes have not been able to actually get the deeds recorded as contemplated by the emergency and temporary bills, and as set forth in this permanent bill. The ongoing dispute in getting parish properties properly and legally titled in their own names has not only been frustrating, but it tends to hinder the ability of parishes to make property improvements, contract with businesses, and complete various projects. This in turn harms not only our parishes, but the neighbors we help in the community. At St. Peter's, we help countless residents in our community, and the vast majority are not parishioners or even Catholic. Other DC parishes have helped thousands more people. Accordingly, I ask the council to enact this bill B 26-641 in such a way and with such language that is needed to allow the historical reality of de facto continual parish ownership of their properties to be acknowledged in the public records without administrative hindrance. I thank you for this opportunity and time, and I'm happy to answer any questions you may have.
Thank you, Reverend Carson. And Reverend Jizu,
Yes, Reverend Ajogo.
please proceed.
Good morning, Chairman, and members of the council. I join with my brother, Father Carson, and the rest of the Archdiocese and affiliates who are here in favor of Bill B 26-641. And I thank you for this opportunity to offer a few words of prayer. My name is Father Cornelius Ajogo, and I am currently the pastor of Our Lady of Perpetual Help, a Catholic church here in Anacostia, Ward 8. And I previously was the pastor of St. Luke Catholic Church in Ward 7 for 10.5 years. Inclusive of all peoples, both parishes that I've served have limited financial means, but we have a very rich cultural heritage of serving not only Black Catholic parishioners, but the whole African-American communities east of the river. Each parish is a passionate, committed, and loving parish of their own, and they cherish the outreach to our neighbors, especially the poor, those who are considered troubled, the outcasts. And our parishioners go out of their way to serve those who are even less privileged than ourselves. As I'm testifying now, there are people ringing my doorbell right now, and I know they're coming here for food and for assistance right now. First, I want to thank Council for passing the emergency and temporary version of this measure earlier this year, with special appreciation to you, Chairman Mendelson, and Council members Parker and Allen for introducing those measures and this permanent bill, B 26-641. Now, by enacting these previous bills, you affirm the justice of ensuring the continued real property tax exemption, and that always existed since the creation of Our Lady of Perpetual Help, St. Luke, and other nonprofit parishes of the Archdiocese that also provide a great deal of support and services to their neighbors and the people around us. Now, ensuring the land record reflects the realities that have existed for decades, with parishes having the properties properly titled in their own names, is likewise a matter of basic fairness and justice. I'm sorry to say, however, that the emergency and temporary bill have not solved the problem of deed recordation and transfer titles. The deeds we seek to record are being held in limbo because of the disagreement with the Office of Tax and Revenue regarding the language of the legislation. This inability to have the parish property properly titled in our own names create a variety of problems for us, the parish and administration, in that inability for us to enter into contract with businesses and to manage projects. This also adversely affects our abilities to do good works for our communities, especially those who are ringing the doorbell right now, and serving both parishes and the greater community at large. To be clear, the church property themselves were purchased and built by contributions, sometimes fish fry and selling little things. They were purchased by these parishioners themselves. so that the parish committee should rightly be recognized as the real beneficial owner of their properties from the beginning, even if they were technically titled under the Archdiocesan Corporation. So due to historic legal restrictions on parish owning properties of their own names. Now the deeds of the parishes we want recorded do not change anything except on paper and merely confirm in law and the public record and realities that the properties have in fact been held and owned by the parishes all along. Now to suggest otherwise is an affront to the many parishioners, my parishioners, and families who have done all they could and built up these parishes and purchased them themselves. So I thank you for the opportunities offered to offer this testimony, and I welcome any questions from the council.
Thank you, Reverend. And the other two, Reverend Antonicelli and Gurney, are not here. So let's see, I have a few questions. I think I'll begin with Mr. Gelman. It seems to me when this issue came to me, the most important thing is that the parishes are tax exempt and therefore should not have to pay the deed or transfer, that's either transfer or recordation taxes. So does it really matter, or why does it matter whether they're labeled as supplemental deeds?
Okay, so a deed of conveyance is a taxable event, so there has to be a citation to a legal exemption. And, you know, in the District of Columbia, an entity that's not a creature of statute, like a general partner, joint venture, an unincorporated association, or previously all these many parishes, could not hold legal title in the district. So besides the parishes, there were many, many other forms of unincorporated legal entities owning properties, but they needed a nominee title holder. And that's what happened in this case. So the Archdiocese received title from the Baltimore Archdiocese to continue to hold nominal title for the real owners, the underlying parishes, as has been testified, who purchased these properties with their own parishioners' money, occupy, use it, and so forth. So it's really their property. And so long existing DC law recognized that situation. And even before home rule and before local district government through the 5 commissioners, there were rules on this allowing for this type of transfer without transfer recordation taxes. It's reflected in 2 existing DC regulations called naked title deeds. Somebody who's just holding legal title for benefit of another, and it describes it as a supplemental deed conveyance. So in good faith and reasonably relying on the regulations, a tax division decision of the Superior Court and the actual definition of supplemental deed, we utilized that in citing to our deeds, and it was rejected, saying you cannot use a supplemental deed, which statutorily is exempt. So then we had no real good option to point to another exemption when the Recorder of Deeds was ignoring their own laws. You know, and that's why we feel characterizing as a supplemental confirmatory deed is 100% consistent with district law. The only rationale that we can vaguely understand from the Recorder of Deeds is they continue, even in today's written testimony, citing to the Columbia Realty court decision. But because they took a legal ruling out of factual context, there was a property owned by a trust with a number of beneficiaries. They created a brand new limited partnership that never existed before, deeded to the limited partnership for consideration, and the resulting limited partners did not even match with the prior owners. So in every factual basis, that court case was distinguishable, but the ruling was where there are separate and distinct legal entities where there's a conveyance for consideration, a supplemental deed is not the appropriate instrument and it is taxable. So it was a distinguishing case that the Recorder of Deeds continues to cite to, even though it doesn't support the preposition that they're trying to make. So we're frustrated. You know, we feel we're 100% following the law, and we just need some additional language in the permanent version of legislation, which will prevent the Recorder of Deeds to continue to reject the recording of the supplemental confirmatory deeds without transferring recordation taxes.
I'm not sure that answered my question. It seems to me that the Office of Tax and Revenue is hung up on the word supplemental. If they say to you, we will treat this as tax exempt, that there will not be a recordation or transfer tax, can't we just remove the word supplemental? Is there any other reason why you need the word supplemental?
Well, because they're trying to hang their hat on the Columbia Realty case, saying this is like the Columbia Real case where you have two different legal entities and it would be a taxable transaction. But as the Archdiocese is tax exempt, maybe we would be exempt from transfer taxes, but the Recorder of Deeds, backed by the Office of Tax and Revenue, is saying the parishes have to reestablish their tax exempt basis through the filing of an FP 300. And for these parishes, that's a huge, burdensome, monumental task to submit these things. And I believe that Mary included in her written testimony how onerous this obligation is to prove something that already is the case, because there's a laundry list of things that have to be submitted. And it takes a very long time for OTR to review, approve, or pick apart and try to decline it on a technical basis.
So what I'm hearing you say is that if it's not a supplemental, if it's not termed a supplemental deed, there's no obvious basis on which to treat the transfer and recordation as tax exempt. And the alternative then would be to file these Form 300s.
Right, you have
that a
to pay
correct
the taxes
understanding?
for, right, correct. And
All right, well, let me ask Ms. Rhodes, how burdensome is this? So if I'm understanding correctly from Mr. Gelman, what's at issue here is, well, Office of Tax and Revenue is saying just file a tax exemption claim. That's the Form something 300, am I right?
yes,
And how burdensome is that? Ms. Rhodes, can you speak to that?
I can. Can you hear me okay? I apologize. I got cut off for a moment.
Yes, I can hear you.
Great. Yeah, and if I can go back also to your earlier question, in terms of the FP 300s, if I understand correctly, that's what you're asking about?
Yeah.
Yeah, so yes, they're extremely burdensome. We agreed last year as a compromise with OTR to submit 4 of our deeds using this application process. It involved, just for those 4 properties, hundreds and hundreds of records that took a lot of our time and resources to put together, to get submitted, and I would imagine it took a great deal of time and resources on OTR's end to then review them. Of those 4 properties, we've received exemption notices for 3 of them that I'm aware of them, and it took over 3 months for us to get those notices. I'm not aware at this point that I've received the 4th notice, and it's been over 6 months since we submitted the application. The thought of having to do that for close to 90 properties, it seems like an insurmountable task. It would take quite a bit of time, a lot of resources, money that we really don't have to spare. And I guess at the end of the day, my issue is it's unnecessary. Existing DC law is very clear, as Mr. Gelman said, these are by definition supplemental deeds. The facts, the law, all support recording these as supplemental deeds. The process otherwise is extremely onerous, but also there's an uncertainty that comes into play when we don't record these as supplemental deeds. It introduces a falsehood into the public records that basically says these parishes never owned these properties before this point, when in reality, I mean, we can all do a Google search and see that St. Patrick and St. Peter and St. Joseph on Capitol Hill have existed for centuries. Long before the Archdiocese, they purchased these properties. So I don't think it's right or fair to introduce this falsehood into the public records. But moreover, this uncertainty that it brings, there are a number of things in DC when you're working with the DC government and third parties too, that you have obligations triggered when you're a new owner. Existing owners are often grandfathered in. And so, for example, we were working with the Department of Buildings for a long time regarding these properties, certificates of occupancy. These parishes are in compliance, but if they're showing as brand new owners, I'm not sure what kind of obligations are going to be imposed on them. I don't have a crystal ball. I can't see into the future. I know that we've had to deal with DC offices in the past. We've had to explain, look, the parishes are grandfathered in because they pre-existed some codes or some such thing. And look, if they were new owners, we would accept that. The fact of the matter is they're not new owners. They've owned these properties, they purchased them. And so again, I guess my question would be not, why not just remove the word supplemental and get the tax exemption, but why is the Office of Tax and Revenue so insistent that we have to remove it when the facts and law say that we shouldn't have to?
Can you say more about the burden of I keep forgetting what they're called, the Form 300s?
Yeah, FP 300.
Ms. Rhodes, can you say more about the burden?
And I'm happy to.
Yeah, I'm sorry. It was a little garbled there. Chairman Mendelson.
Yes. Did you not hear me?
Yeah, I heard something about the FP 300s, but unfortunately it was slightly garbled.
Can you say more? I want you to describe in more detail what the burden is of filing these FP 300s.
Sure. So it's been since December since we did the last round. There's an application, and then the application lists, I believe at the end or in the instructions, a series of maybe 10 different documents that have to be included. When I say 10, each of the 10 items there may have subsets. So 10 may really be 3. You have to go back through the incorporation documents, parish historical records, financials and assets. And I apologize, I don't have the list in front of me, but I can tell you it took many, many hours and lots of documentation, multiple people in our offices coordinating with the parishes just to put together the applications and documents for these 4 properties that we did in December. I'd also be happy if it would be helpful to write up a very brief summary to submit afterwards to just let you know a brief overview of what that process is.
Sure. Why don't you do that? Mr. Gelman, did you want to add to that?
Yeah, so to be a supplemental deed, you include the relevant facts that justified being a supplemental deed. So if the term supplemental was removed, it would look like any other taxable ordinary deed that's out there. So, so we would, it wouldn't be, a deed would give the public the impression that complete legal and beneficial ownership changed from the Archdiocese to the parishes, and that's not what the true facts are. And we are very uncertain about what the practical and legal implications of putting a regular deed on the public record that gives the world the wrong impression of the underlying facts. And as Mary said, we spent many hours with the Department of Buildings trying to understand what the requirements would be in terms of inspection of century-old parish buildings. They predate, various building codes, certificate of occupancy requirements, and we could not get a handle on what nightmare and burden would be facing us for years following recording an ordinary deed that was statutory exempt. Because a supplemental deed it's not a real change of true ownership. It's the nominal holder of legal title for the benefit of the true owner, and we're just merging those together. And so we just want to be factually and legally correct under existing DC law, because doing it otherwise, there are so many unknown consequences we can't get our arms around.
Thank you. So, looking ahead to the testimony from the Assistant General Counsel for the Office of the Chief Financial Officer, they state, the Archdiocese has already transferred certain parish properties to these recently organized parish corporations, and the Office of Tax and Revenue has exempted the properties for which properly completed applications have been submitted. The current process has functioned effectively to date, and it appears that the existing administrative exemption framework could continue to serve as an efficient approach for the remaining Archdiocese parish properties. I'm not hearing from you that you think it's sufficient. And in fact, didn't I hear you say, Ms. Rhodes, that you're only aware of 3 of the 4 applications that have been granted?
And Mary, if I could, you're on mute. Sorry.
That is, I'm aware of only 3. Our records show only 3 of the 4 have been returned.
Mary, the 4 that were selected, was that because those were 4 deeds that were presented and rejected, but the DC government pretended that a transfer had occurred, even though the deeds weren't recorded and we were caught in a bind? Or did you select 4 different parishes?
No, that's correct as best as I understand it. We had back in 2023, rather than inundate the recorder of deeds with, close to 100 deeds, our title company said, hey, we'll start with 4, make sure they understand what's happening here. Those deeds were rejected, which started a 2-year plus, now going on 3 years process of trying to get them recorded. Maybe I can't remember exactly when, maybe about a year or so later, even though the deeds were rejected, wouldn't be accepted, those parishes then received tax bills, which ultimately wound up in about $2.5 million in tax penalties that were going to be imposed unless we work this issue out. So of course we wanted to avoid litigation. And this was our first time that we were actually able to meet with OTR in person to try and discuss this. And we decided as kind of a compromise, okay, they said you record these with the FP 300s and, we'll accept them. So that is what led to our using these 4 properties really as a matter of necessity. And it was somewhat, I don't know if ironic is the right word. It was disappointing. Like one of the properties was St. Anne's Catholic Church in Tenleytown. And one of the vesting deeds for that property actually said on it, and I don't know if it was from the 1800s or 1900s, but this property is being held in the name of the Archbishop as trustee for the use and benefit of St. Anne's Catholic Church. It was actually pursuant to TC legislation. So even though the deed itself recognized that the parish was the owner, we weren't able to use a supplemental deed. We had to pretend like the parish was a brand new owner. And as mentioned, it involved many, many hours and hundreds of pages of documents to get those submissions in.
Any other questions? Thank you. I don't think I have any other questions at this point. Thank you, all of you, for your testimony.
Thank you very
Thank
much.
you.
I'm going to turn now to Bill 26700, which is the Reservoir District Tax Exemption Amendment Act. I have 3 witnesses, Ruth Hong, Senior Vice President of Development at Jair Lynch, Real Estate Partners, Emily Alexander, Senior Development Manager at Shire Lynch Real Estate Partners, and Robert Vincent Branham, who's Chairman of the DC Federation of Civic Associations. Ms. Hong, do you want to start?
We're actually going to switch between us, if you don't
Okay.
mind. Good morning, Chairman Mendelson and staff. My name is Emily Alexander, and I'm a Senior Development Manager at Gyre Lynch Real Estate Partners and a Ward 5 resident. Thank you for the opportunity to testify on the Reservoir District Tax Exemption Amendment Act of 2026. I am here today to urge the committee to pass the permanent legislation as written. As you know, Councilmember Parker introduced the emergency legislation, and it was passed unanimously by the council. The emergency legislation is currently in effect, and the legislation before you would ensure the ongoing amendment of to the tax exemption. The Reservoir District is a transformative mixed-use development that reflects the district's commitment to housing production, economic development, and effective public-private partnerships. We are extremely grateful to this council for passing the tax exemption last year in the fiscal year 2026 Budget Support Act. However, a misalignment between the rent assumptions in the project's tax abatement financial analysis, TAFA, and current inclusionary zoning rates threatens the economic feasibility of delivering the planned housing. As you may recall, the TAFA for parcels 2 and 4 of the Reservoir District was structured using rent rates based on the U.S. Department of Housing and Urban Development, HUD's multifamily tax subsidy project income limits. In February of 2026, the Department of Housing and Community Development published updated inclusionary zoning rates. The updated rates do not match the rent rates based on HUD's multifamily tax subsidy project income limits. This creates a problem because the statute granting the Reservoir District project and tax exemption requires the project to use inclusionary zoning rates, even though the project's financial underwriting was structured using rents based on HUD's multifamily tax subsidy project income limits. If the project is required to operate under the current inclusionary zoning rates rather than rent rates based on HUD's multifamily tax subsidy project income limits, the resulting revenue shortfall would render the development economically infeasible. The proposed bill offers a narrowly tailored solution. By allowing the project to operate under HUD rates, you will restore consistency between the statutory framework governing the tax exemption and the assumptions used to finance the development. The legislation would not alter the existing tax exemption, provide any new subsidies, nor change the affordable requirement of projects that have previously received tax abatements. It is a technical correction intended to address the discrepancy between inclusionary zoning rates and HUD rates that occurred after our project's approval. We request the committee advance this legislation as written without adding an affordable covenant requirements. Adding an affordable covenant to a tax abatement that has already been approved by the council and written into DC code is not standard practice. Imposing this additional requirement on the Reservoir District would set a precedent for future tax abatements, which we do not believe is warranted. The tax abatement is already written into the DC code based on our square and lot numbers, not as part of a larger abatement program. Without the Reservoir District Tax Exemption Emergency Amendment, the project was at risk of delays that would have hindered the delivery of much-needed housing and undermined the district's broader development objectives for the Reservoir District. This bill is the most efficient mechanism to resolve the issue permanently and maintain project momentum. I urge the committee to approve this bill to ensure the development of the Reservoir District has the opportunity to proceed without disruption. Thank you for your consideration and for the opportunity to testify. I'm happy to answer any questions.
Thank you, Ms. Alexander. Ms. Huang?
Good morning, Chairman Mendelson and Lane. My name is Ruth Hong, and I'm the Senior Vice President of Development at Gyre Lynch Real Estate Partners. I appreciate the opportunity to offer testimony on the Reservoir District Tax Exemption Amendment Act of 2026. I am testifying today to urge you to pass the Reservoir District Tax Exemption Amendment Act of 2026 as written. The Reservoir District is one of the district's most important public-private redevelopment efforts, transforming underutilized land into a vibrant mixed-use community. This project encompasses the district's goals of housing production, economic development, and smart land use. However, the project's financial viability is at risk if the emergency legislation is not made permanent. In her testimony, my colleague Emily Alexander explained the issue we are seeking to resolve with this legislation. It is paramount we solve this problem in order for this project to move forward. I want to emphasize that while the per unit difference between rent rates based on HUD's multifamily tax subsidy project income limits and inclusionary zoning rates may appear modest, ranging from $14 to $126 depending on unit type, the cumulative impact is substantial. Monthly gaps translate into significant reductions in annual operating income. At the scale of this affordable housing project, the discrepancy between the rent rates based on HUD's multifamily tax subsidy project income limits and the inclusionary zoning rates cannot be absorbed and directly threaten the economic feasibility of the project to move forward. The proposed bill does not expand the existing tax exemption, reduce the total number of affordable units, and provide any additional subsidies from the district government. It is a targeted technical fix that aligns the project's statutory requirements with the financial assumptions under which it was underwritten. Without this bill, the project is at risk of delays that would jeopardize delivering the proposed multifamily housing. There's been discussion by the administration about requiring an affordability covenant to be recorded. Such a requirement is necessary and consistent with other tax exemptions of this kind. The Reservoir District's tax exemption is codified in Chapter 46 of Title 47 of the DC Code and specifically identifies applicable square and lot numbers, making the terms of the exemption and the properties to which it applies explicit in statute. This differs from programs such as housing in downtown or Office to Anything, where recorded covenants are used to memorialize project-specific obligations that are not otherwise established in the DC Code. The purpose of this legislation has always been to make a targeted technical correction. We request that this bill move forward without any additional provisions or amendments that were not part of the emergency and temporary legislation, so we can ensure our equity providers and investors in this project will be built according to the terms agreed upon and will be in effect immediately upon becoming law. Passing the Reservoir District Tax Exemption Amendment Act of 2026 is the most efficient and timely path forward. I urge the committee to advance this legislation to ensure this correction is enacted and the project is able to proceed as planned. Thank you for your attention and for the opportunity to testify. I'm happy to answer any questions.
Thank you, Ms. Huang. Mr. Branham.
Good morning, Mr. Chairman, members of the committee. My name is Robert Vincent Branham. I am President Emeritus of the DC Federation of Civic Associations, a former advisory neighborhood commissioner, and a resident of Bloomingdale along the corridor that encompasses the McMillan Reservoir. I have been involved as a community activist in the citizen concerns about the development of that particular site for a number of years, even when I was a board member of the North Capitol Main Street. I want to piggyback on the testimonies that have already been presented and express my support for the legislation. It is critical that this project continue and move forward, and that the economic development options proceed quickly. There are already some delays in getting occupants for the property. Original occupants, desired occupants have walked away from the project, leaving the project subject to unmerited, unnecessary delays. And it's time to move forward on this project. And let me say also for the record that I'm a former president of the Bloomingdale Civic Association, and we have been involved in the issues surrounding the development of the reservoir for a number of years. And I strongly support this legislation. And on behalf of the DC Federation of Civic Associations, I want to align myself with the testimony that have been presented and express support for the legislation. Thank you.
Thank you, Mr. Branham. I think I just have a couple of questions. Ms. Alexander, in your statement, you said near the end, we request that the committee advance this legislation as written without adding any affordability covenant requirements. Where does that notion come from?
There are affordability covenants required by the LDDA associated with what is, after the PUD modification, is now Parcel 2 East. that we are working with DEMPED to update. And through conversations, they've identified a desire to have covenants associated with the tax abatement. We don't believe that is standard practice or kind of historically necessary, and would like to avoid adding extra covenants to the land when it is already codified by law, but that's where it's coming from.
I'm not sure I'm completely following. So the reservoir site
Mhm.
is divided into several phases and parcels, and there
Yep.
are, I think, several developers. If I'm understanding what you're saying, there's right now some negotiations going on with regard to other portions of the site
Correct.
and
The-
some affordability being talked about there. But there's also some talk about taking that affordability requirement and, if you will, retroactively applying it to this site.
There's discussion of kind of commingling the tax abatement affordability and the land development affordability and requiring covenants to cover both rather than maintaining the land development affordable covenant as its own independent covenant that will be allocated per the PUD modification and the tax abatement being per the DC law and code. So there's attempt to commingle or not attempt, request to commingle them and not execute one without the other.
My impression, am I incorrect in my impression that we're also talking about two different pieces of land there?
Yes, the land development is on what is considered parcel 2 east, which is a completely affordable senior affordable development. And the tax abatement is on parcel 2 west, so considered the same square, and parcel 4, which is not part of the parcel 2 east senior development.
If I may, Chairman.
Two east, two west, and
Parcel 4, which is the grosser parcel, which are the two parcels that we own broken
Yeah.
up by tower.
If I may, just
Yes.
the affordable housing requirement for all of Reservoir District for the multifamily parcels is for a senior affordable component. That is going to be in parcel 2 east. The tax abatement here that we've had approved by you and the council does not cover that parcel. It's just on parcel 4, which is the market rate housing with the proposed grocery on the ground floor, and then parcel 2 west, which is a market rate multifamily project. And so as we've been talking to DEMPED about updating the covenants that run with the land to cover the affordable senior component for the LDDA and what's been approved in the PUD as of last year, they have been sort of conflating that because there's a covenant required for the senior affordable component, that we should now have that they feel like the city should have a covenant for the other two components, for parcel 4 and parcel 2 west, that are covered through the tax abatement. And as you know, we testified, those tax abatements are codified, through the legislation, and the requirements are in law. And so it would be kind of redundant to have a covenant that runs with the land plus having it also in the legislation as well.
Okay, give me a second. I don't have any other questions for y'all. Thank you very much. The remaining witnesses appear to be related to some or all of the remaining bills. 26-252, 360, 476, and 26-484. I'm going to call witnesses until either I think I have enough or that table is full. Deborah Cuevas Hill, Managing Attorney with Legal Counsel for the Elderly. Nikitia Burko, who's Staff Attorney with Legal Aid DC. Erica Wadlington, Vice President of Public Policy and Strategic Affairs at DC Building Industry Association. Rasan Bernard, who's Chief Operating Officer with WC Smith. Is Rasan online? I'll stop right there. Ms. Hill, you're first.
Yes. Good afternoon, Chairman Mendelson and Mr. Stum. I'm Deborah Cuevas Hill, manager of the Consumer and Home Ownership Preservation Team at Legal Counsel for the Elderly. I'm here to testify in support of B 260360, the Senior Tax Aggregation Amendment Act of 2025. This bill will have a real and immediate impact on several of LCE clients, keep seniors housed, and protect generational wealth. For more than 50 years, Legal Counsel for the Elderly, LCE, has defended, protected, and empowered the District of Columbia's vulnerable older adults. LCE is the only legal services organizations in the city that exclusively serve seniors. The consumer team defends seniors facing foreclosure. Current DC tax law makes inheriting a home far too expensive for some district residents, stripping families of generational wealth. Like other jurisdictions, the district provides seniors with property tax breaks at certain age and income levels. However, DC goes further to require that the party claiming property tax benefits have an ownership of 50% or greater in the property. So if two seniors live in a property and neither has a 50% interest, but their combined interest would meet that requirement, they cannot avail themselves of property tax benefits. Simply put, if 4 seniors lived in a property, each owning 25%, all of them live in the property, they still wouldn't be able to qualify for tax benefits. In other words, someone who works hard to pay off their house, raise a family there, age there, and have the senior homestead rate, when their 3 senior children inherit the home, those children will have to pay a higher property tax rate, even if by age and income level, they would otherwise qualify for senior property tax relief. The Senior Property Tax Aggregation Amendment Act of 2025 fixes this problem in a relatively simple way. The bill allows 2 seniors to aggregate their ownership interest to meet the 50% requirement if they live in the property and would otherwise qualify for property tax relief. Let me give you a real example of how aggregation can save a family property. The Johnson family, who just submitted written testimony today, are facing foreclosure because the district sold their tax lien during the 2025 tax sale. The Johnson sisters have lived in the house mostly since their parents purchased the home in 1969. In fact, this is the only home the youngest sister has ever known. But when their mother died in 2018, they, along with their brother, who died earlier this year, each inherited a 25% stake in the house. The 2 oldest sisters who live in the property would qualify for senior property tax relief, but because neither owns 50%, they're stuck with $15,000 in taxes, penalties, and interest. Are risking foreclosure. Had they been able to aggregate their interest after their mother passed, they could have afforded the taxes. Because current law prevents them from aggregating or combining their interest in the house, they face foreclosure and the loss of the home where the family hosted Christmases, where they grew up, in the neighborhood where they went to school, where their mother aged, thinking she could provide some security for future generations. While this is about an asset, this is also about the district creating a fair process for families to keep their homes in their communities. The council must pass the Senior Tax Aggregation Amendment Act of 2025 and help families like the Johnsons and my clients keep their families' homes. Thank you, and I'll be happy to answer any questions.
Thank you. And I don't have a copy of your statement.
Not yet, Your Honor. I'll be submitting it.
All right.
I
thank
mean,
you.
I had a hearing, Chairman Mendelson.
Yes, I noticed that. Thank you. Mr. Burko?
Good morning, Chairman Mendelson. My name is Nkitio Burko, and I'm a staff attorney at Legal Aid DC's Consumer Law Unit, speaking today in support of the Senior Property Tax Aggregation and Disabled Veterans Complete Property Tax Exemption Acts. Legal Aid's consumer law practice focuses on foreclosure defense work along with other areas. In our foreclosure defense practice, we represent district residents facing a variety of issues, including property tax foreclosures. Through our casework, we have seen how inequitable access to property tax benefits places elderly homeowners at risk of losing their homes. We've also seen how disabled veterans might benefit from expanded property tax benefits to reduce their housing cost burdens. Legal Aid supports the 2 bills named above and appreciates the introducing council members' proactive approach to protect DC's most vulnerable residents from housing insecurity. We encourage the committee to strengthen the Senior Property Tax Aggregation Amendment Act by expanding the senior tax relief to all senior homeowners with an ownership interest in their property in their primary residence. First, Legal Aid supports the committee's passage of the Senior Property Tax Aggregation Amendment Act. Legal Aid has seen too many senior homeowners who, despite living in their home for decades, are unable to access property tax benefits simply because their ownership interest in the home is under the 50% threshold. Exclusion from this vital property tax benefit is particularly harmful for our clients, many of whom reside in neighborhoods with skyrocketing assessed values that far outpace their fixed incomes. Seniors should not face property tax foreclosure simply because they are one of several owners in a home. Permitting heirs to combine their ownership shares to qualify for the senior tax benefit will protect many of our clients and others in their shoes from burdensome housing costs. With the proposed legislation, the district will join other jurisdictions in adopting flexible, common sense eligibility criteria to allow elderly heirs to age in place. Legal Aid also encourages the committee to build upon this initiative by allowing seniors with an ownership share under 50% to qualify for the senior tax relief. While in some instances, one resident heir may be able to aggregate their ownership share with another to qualify for the senior tax relief, in other cases, the 50% threshold may act as a barrier to relief. The council has already demonstrated its commitment to preserving homeownership for heirs through initiatives such as the Heirs Property Assistance Program and Partition of Real Property Act. Removing the 50% threshold requirement for senior tax relief would build upon these prior efforts by ensuring more of the district's residents can reduce their property tax burden and avoid being displaced. While the proposed Senior Property Tax Aggregation Amendment Act goes a long way toward ensuring heirs of color can access vital property tax relief, we believe the committee can further protect elderly heirs by expanding eligibility for the senior tax relief to homeowners with an ownership share under 50%. Finally, Legal Aid supports the proposed legislation to make the disabled veterans property tax exemption deduction a complete property tax exemption for veterans and their spouses. The proposed legislation would significantly reduce the housing cost burdens of our clients who have been injured in the line of duty, and we fully support the bill as written. The two bills I've discussed would make significant steps toward the district's goal to protect elderly and disabled district residents from preventable home loss. Our requested additions to the bill would only further the legislation's goals of keeping DC residents in affordable family homes. We thank the committee for the opportunity to submit this testimony, and we urge the committee to pass these bills. Thank you.
Thank you, Mr. Burko. Erica Wadlington.
Thank you, Mr. Chairman, staff, Ms. Bonds. I'm Erica Watlington with DCBIA. Thank you for the opportunity to testify on Bill 26252. DCBIA appreciates the council's focus on improving the district's real property tax assessments and appeals process. A predictable, fair system should reflect market conditions, and appeals processes should be able to provide a stable tax base. While we support reforming this process, we believe this particular bill focuses its efforts in reform on the wrong issue, rather than the underlying methodology and valuation issues driving some of the volume of appeals. We do not recommend the committee move forward with this particular bill. We would like to flag a couple things regarding this legislation. Bill 252 would establish a separate assessment and appeals calendar, one for those income-producing properties and another for all other properties. As you will read in today's testimony, maintaining two different calendars will create additional administrative complexity, not just for property owners, but we believe also for practitioners, the agency, RIPTAC, without addressing any of the existing deficiencies in the assessment and appeals process. The bill also revises several statutory deadlines for those income-producing properties, including moving the deadline for I&E reports and income and expense reports, delaying proposed assessments, and extending the deadline for the first level appeals, while also providing RIPTAC with maybe 2 more weeks to issue their final decisions. However, extending these deadlines alone is not meaningful if the district doesn't have the capacity to meet them. Our members have reported receiving RIPTAC decisions late as May of this year. And this is the case for all appeals, not just ones involving income-producing properties. So without reducing the volume of appeals or providing the agency and RIPTAC with additional staffing or operational resources, creating a separate process with adjusted timelines is unlikely to meaningfully address these concerns. The fundamental issue our members face isn't the calendar. It's that the valuations don't reflect the market realities. Addressing the accuracy and consistency of the agency's valuations at the forefront is the most effective way to reduce appeals, improve timelines, and ease the workload on both OTR and RIPTAC. So DCBIA recommends that the council focus reforms on things that improve the valuation process itself. So we are recommending giving appropriate weight to independent appraisals before, when they are presented before the appeals process. These can be submitted by licensed appraisers. Property owners can be deemed to have met their burden of proof when they submit this documentation during the appeals process. We also recommend clarifying the statutory definition of market value and allowing appeals involving the same property to file those appeals across multiple tax years. They could be consolidated into a single proceeding just to ease the burden on both RIPTAC and the Superior Court. These and other recommendations discussed in greater detail throughout our collective record testimony, and other DCBA witnesses will be following me to expand upon those, are intended to improve the accuracy, the consistency, and the credibility of our assessment process, while also reducing the unnecessary appeals. So DCBIA looks forward to working with you, your committee, and both agencies to develop reforms that improve the fairness and efficiency of our assessment system. But let me be clear, we do not think that this bill gets us very far. So we would ask that you reconsider this proposal, but we'll love to work with you on other ideas. Thank you for the opportunity to testify. I'm happy to answer questions.
Thank you, Ms. Wadlington. And Mr. Bernard.
Good morning, Chairman Mendelson, Councilmember Bonds. My name is Rasan Bernard, and I'm a Ward 8 resident and the Chief Operating Officer for WC Smith. We are a 58-year-old district-based company that owns or manages nearly 9,000 apartments throughout DC, including one of the largest portfolios of affordable housing in the city. I want to thank you for the opportunity to provide testimony on B26252, the Real Property Assessment and Appeals Schedule Revision Act of 2025. As with my colleague on this panel, WC Smith appreciates and supports the council's efforts to improve the district's real property assessment and appeals process. However, we share their concerns that the bill focuses on procedural timing, creating schedules that shorten deadlines for OTR and RIPTAC. These agencies are already under capacity and can't meet the current longer deadlines. B26252 would exacerbate the conditions that underlie a broken process. It also creates deadlines for property owners that are nearly impossible to meet. For example, the bill would require us to file our I&E statements by March 15th. This is unreasonable as it hits in the middle of tax preparation season, the busiest time of year for any accounting team. Moreover, OTR does not even consider I&E statements when proposing assessments for multifamily properties. Instead, the agency relies on a computer-assisted mass appraisal system to make these determinations, thus disregarding actual property performance. A more effective direction is to address the lack of transparency in OTR's process, which produces inaccurate statements leading to lengthy appeals that clog the system, costing taxpayers and the city time and money. Respectfully, Mr. Chairman, if you remember nothing else from my testimony today, I hope you'll remember these three recommendations that we would have benefit taxpayers and the city, all in the name of transparency. First, change the process and allow taxpayers to access the worksheets and other information OTR uses to determine assessments. Currently, we can't see what factors assessors consider for a property until an appeal is filed. By giving us, as taxpayers, the opportunity to review this information, once the proposed assessment is issued, we can point out any errors and arrive at a more accurate tax rate without having to appeal. Allow me to give you an example as it relates to our affordable properties. These properties often have covenants through which we have committed to long-term affordability for our residents. This means that the rent on many, if not all, of all the units fall well below market rates. Yet, OTR will often disregard these covenants when preparing its assessments. This happens routinely at a tax credit property in Northwest Washington we acquired in 2014 through TOPA. Every unit is affordable at this property. In fact, many of the tenants remain from the original development. For these residents, we are contractually obligated to charge rents well below even tax credit allowable amounts. Despite providing copies of the purchase agreement and covenant, as well as rent roll for the date of evaluation to the assessor, each year the assessment is based on this CAMA modeled rents, and does not reflect the actual income of the property. We haven't received a value relief for these properties and had to appeal the decision each year. Second, OTR must make available the sales comps that it uses for market valuations. Unless we press for that, we have no way of ensuring that the comps accurately reflect local market activity. As an example, the assessment recently increased 30% and 28% respectively on two affordable properties in Ward 8 that are in neighborhoods where there have been very few, if any, property sales. So we ask, where did those numbers come from? Moreover, market rate property sales continue to drop throughout the city, yet assessments don't reflect these conditions. Finally, OTR must offer transparency in how cap rates are determined for each property. Under the current system, cap rates between affordable and Class A properties do not reflect market conditions and are often too close to one another. We urge the council to reject this bill and instead enact legislation that would fix these flaws in the assessment process and give OTR the resources it needs to more accurately prepare assessed values. Thank you, and happy to answer any questions you may have.
Thank you, Mr. Bernard. I think I have a couple questions. Ms. Wadlington, I was looking at your statement and I couldn't find what you said. 80% of your members say that the RIPTAC decisions are late?
I think we were quoting the percentage of decisions that are not meeting the deadline, the statutory deadline that was in the RIPTAC report provided to the agency, provided to the council. But majority of our members are not receiving their decisions by the statutory deadline.
Well, you do say in RIPTAC's FY25 Performance Accountability Report, and by the way, we requested RIPTAC to be here to testify and they chose not to. And I followed up, right? You're going to be here? Okay, I take all that back. I'm told they will be here. I sent an email yesterday. So I take all that back. In the report, I'm looking at your testimony, only 10.79% of those cases had decisions issued within 30 days. Is that what you're referring to? It's page 4 of your statement.
Yes, sir.
Okay. And then, and I think part of your objection to the bill is that they're not meeting the 30-day deadline and the bill is expanding that 30-day deadline to larger properties. Am I
Yes.
understanding correctly?
Yes, sir. And so we're supportive of giving the agency a little bit more time if that is necessary, but we're also skeptical that given their current, capacity and even the, history of not receiving it on time currently, that it's able to meet that obligation. So we wanted to flag that for the committee because it's something that we've been mentioning in our oversight testimony for a little bit about not receiving their decisions by the statutory deadline. It's common, it happens, but we would love for them to meet their statutory deadline and we would support that happening moving forward.
Give me a second. I'm going to turn to my colleague, Councilmember Bonds. Do you have any questions?
Oh, yes. Thank you very much, Chairman, and thank you very much to the witnesses, and particularly thank you to this very important audience that's listening in, care a lot about assessments and values of our real estate. It's great to know that you are here and want to be a part of where we need to go as a government. I don't think anyone here is surprised to know that I care very dearly about where we're going with the assessed value of our properties. And so to that end, I do have a few questions, and I want to start with, I would normally start with the elderly issue, but let's talk a little bit. I only have a few minutes, I see, okay. Let's talk about the covenants that are on properties. And I think you indicated, Mr. Bernard, that many of the covenants will state a rent level. That's the interpretation of what I heard you say. Tell us a little more about that, because that's very important. In a town where people are saying the rents are too high.
Yeah, specifically the reference I made in my remarks, a property that we have a covenant for affordability, 40, 50-year covenant, where rents were obligated to not increase the rents more than 4% a year. Since the inception of that property, today, those rents are below market levels. And actually, they're below affordable allowance levels, tax credit levels, sorry. And so those have stayed low. And so the value of that property using income and expense statements should be viewed differently than a property that does not have those affordable covenants. And so we see the CAMA system, which we understand why it's used for mass valuation. But when we're assessing these properties that have covenants, we believe by providing the covenants, by providing the documents that rightly sizes those properties based on income, it should be considered when evaluating the taxes for that property. And so that's the reason why we want to bring that up. So it's not aggregated with properties that are performing at market rate, at market levels, rightfully so, being paired with properties that have these covenants that are clearly producing less income.
Okay, well, this is also, thank you very much for that response. This is also related. As you know, we have a number of buildings in the commercial buildings in the city that have vacancies on the ground floor, but we also have some residential buildings that are required to have commercial space on the ground floor. What is your thought about the vacancies of ground floor space? What's your thought about that? And the Smith Company?
Yeah. So, you know, it's interesting because I think when we think about let's use our Skyline Workforce, our Skyline Town Center as an example. You know, we have exogenous factors, obviously, in our current market that impacts retail, impacts vacancies. We actually are looking at right now adding 126 townhomes at Skyland and condominiums that we hope will improve the retail that's there at the town center. So we believe in obviously having ground floors being occupied by residents, being occupied by retail. We want the vibrancy that occurs when those things occur in our city. It's a very, very difficult time. And we actually believe that residency, meaning getting the vacant apartments filled with DC residents, will drive the retail for any given project. And so we feel very strongly about that. And we also believe that we have a vacancy problems because the cost of turning over a property today is costly. And if we can't, if we have arrears in rent, we have rising costs, it's very difficult for us to turn properties over quickly for people to reduce that vacancy and ultimately drive, again, ground floor traffic, ground floor retail, all of the above. So it's really a chain reaction.
Thank you very much. I ran out of time, but I would like to submit some questions for the team that spoke on elderly housing for sure, and to the chamber itself. I think these are issues we really have to wrestle with. I'm hoping to hear from the legal team that for the elderly, that you'd like to see elderly in some of these ground floor properties, those that have ambulatory needs. But thank you very much, Chairman.
Thank you, Councilmember Bonds. Thank you, each of you, for your testimony. And Ms. Hill, remember to give us a copy of your statement. Scott Kreider, who's a shareholder with Wilkes Artis, Tanya Castro, Salim Adolfo, who's chairperson of ANC 8C, Joe Riley. These people online.
That's okay.
Salim Adolfo.
No,
I know. Joe Riley?
This is bad.
Joe Riley, you're Joe Riley.
It is. We go. This is good stuff. It is stuff. I love it. Absolutely.
Grant Steinhauser, Principal for Real Property Tax at Ryan LLC. Let's see.
Touches everything.
Mr. Branham, are you trying to get my attention? No, you're not. Yeah, you're witness number 25. We're witness number 19. We appreciate your enthusiasm. Mr. Kreider. Mr. Kreider, you're up.
Morning. Thank you, Chairman. Good morning, Chairman Mendelson, Councilmember Bonds. My name is Scott Kreider. I'm a shareholder at Wilkes Artis. For more than 50 years, we have represented district property owners in real property tax matters, and today we represent hundreds of them. I'm here in opposition to Bill 26-252, and I would like to emphasize 3 points regarding this bill. First, the bill significantly shortens the first and second level appeal timeframes in a way that is bound to frustrate the appeal process and drive more appeals to DC Superior Court. At the first level of appeal, let me walk you through what I mean. Currently, the appeal timeframe runs from April 1, when you submit the appeal, till August 1, when the Office of Tax and Revenue issues its decisions. That is a 4-month period. During that period, I kind of like to characterize it as ping pong between taxpayers and the Office of Tax and Revenue. We submit our appeals. We then request information from the District of Columbia Office of Tax and Revenue regarding how they assess the property. That process takes months right now. So the taxpayers request the information regarding how the assessors have valued these properties. Then the taxpayers have to analyze that information, both the assessment and the financial performance of the property. They have to then identify any issues with the assessment. Then there is an appeal hearing with the assessors in which information and arguments are presented to the assessors. The assessors then have to go review that information, talk with their supervisors, and issue decisions, all within that 4-month time frame. This bill would reduce that time frame from 4 months to 2.5 months. It's simply not a practical reduction in time frame. Look, right now the system's tight but workable. All the stakeholders are racing through these 4 months to get through the process, and we just get through it in barely enough time. Reducing that process by, like I said, a month, from 4 months to 2.5 months would frustrate the process and just push more appeals forward to the second level, which then I'll go forward to that. You heard Mr. Mendelson from Ms. Wadlington about how RIPTAC is not meeting its current decision deadlines. This year, we did not receive approximately 40% of our decisions by the February 1 deadline. What does this bill do? The bill does 2 things. One, it reduces the time the taxpayers have to file appeals at RIPTAC from 45 days to 30 days. No purpose for that. And then it reduces an already condensed RIPTAC appeal hearing schedule by 40%, from 5 months, September through January, to 3 months, mid-November to mid-February. Again, this would simply frustrate the appeal process and result in more appeals being pushed to DC Superior Court. Second, the bill, quite frankly, just addresses the wrong problem. OTR's stated reason for this bill is that it needs more current income data to produce more accurate assessments. That is not the issue that is driving appeal volumes. The issue now is OTR is basically disregarding market sales. For the past 3 years, the district has looked at nearly every sale and said it is a non-market sale, and they have excluded it from their valuation models. What this has resulted in is assessments that are untethered to market realities. And that is why you're seeing taxpayers and property owners frustrated with assessments. And finally, I'm bringing this up for the first time this testimony because this is a relatively recent phenomenon. We have just recently started receiving threats of increased assessments from OTR assessments at the first level. So we go into the appeal, we present information showing the assessment should be decreased. We're getting emails and calls from assessors saying, if you don't withdraw your appeal, we're going to increase your assessment. Whatever the intent, the effect here is clearly to discourage property owners from exercising their appeal rights, and we believe this presents real fairness and abuse of process concerns in the system. I'm over. I appreciate my time and available for any questions that the council has.
Thank you, Mr. Kreider. Ms. Castro.
Good morning, Chairman Mendelson, Councilmember Bonds and staff. My name is Tanya Castro. I'm co-founder of Castro Haas PLLC. I've been handling real property tax matters in the district and Northern Virginia for 40 years. Thank you for the opportunity to testify on Bill 26252. I'm going to pick up for where Mr. Kreider will play tag teaming here. We think, again, that better quality assessments should be the goal here, and that changing the appeal cycle is not going to achieve that goal. As mentioned in other testimony, the bill would establish two separate assessment and appeal calendars, one for income-producing properties and one for all other properties. So you could have an owner with an income-producing apartment building, but land that they need to develop, and they'd have two different calendars for those two different properties. I also note that the introduction to the bill references that it would apply to large valued properties, but that isn't really defined in the bill. And currently, we have an example of a property that's assessed at only $1.7 million has to file an income and expense form. So that would be included in the current list of properties that would be subject to this legislation. Among the adjustments to the calendar include moving up the deadline to file income and expense forms, and then also changing the date to mail the assessment notices. The parent goal is to provide OTR with the most recent income and expense data so that they can presumably do a better job coming up with their values. We think this is a solution in need of a problem. The current system allows for the district to have the most recent income and expense form at the first level. They have that information, so then they can make adjustments during the appeal process. The calendar would also give the staff only 2.5 months to do the work that OTR staff currently has 10 months to do. In my experience over the past 40 years, completing all of those steps effectively in 2.5 months is just not possible. I would also note that other local jurisdictions have calendars similar to the current DC calendar, and those jurisdictions are able to issue better quality assessments with substantially lower appeal rates. Let's skip to that. We support better quality assessments, so we have a couple of recommendations for consideration. First, we think the legislation should be introduced to clarify that assessments must be based upon generally accepted appraisal practices, procedures, rules, and standards as prescribed by nationally recognized professional appraisal organizations. This would be consistent with the Virginia Code. Current methodology, which is the result of all of these high level of appeals, is not consistent with generally accepted appraisal practices. We think the district should also establish a statutory framework allowing for property owners to consolidate disputes involving the same property across multiple tax years, multiple years in one proceeding. Again, this would be consistent with how the Virginia Code is set up. For example, in Virginia, taxpayers often wait until they have 3 years of assessments to challenge before they file a lawsuit, and then they can proceed forward with one lawsuit. These recommendations would address the main reasons why there's so many appeals in the district and would improve the accuracy of assessments and thereby reduce the number of appeals. Thank you for the opportunity to testify, and happy to answer any questions.
Thank you, Ms. Castro. Salim Adolfo is not here. Joe Riley?
Good morning, Chair Mendelson, Councilmember Bonds. My name is Joe Riley. I'm a regional managing director in commercial property management. I've been managing office buildings downtown for 24 years. Thank you for the opportunity to comment on Bill 26-252, the Real Property Assessment and Appeals Schedule Revision Act. My testimony today is focused simply on the proposed change to the income and expense form filing deadline, moving it from April 15th to March 15th. It sounds simple, it's just a month. And I appreciate the desire to provide assessors with the information earlier in the assessment cycle, but I believe moving the deadline forward by a month will significantly reduce the accuracy and reliability of the information provided. The most immediate challenge is obvious. It's timing. Property owners and managers simply do not have complete and finalized year-end financial information by March 15th. Many expenses, think about utilities or contract vendor billings, they routinely lag by weeks or maybe more than a month to the close of the calendar year. And it's not until we receive those invoices and code them, review them, enter them, before we can start to finalize all our statements. At the same time, we're simultaneously completing all our other year-end stuff, accounting close, financial reporting, audits, tax-related reporting, and every other year-end obligation. Compressing the income and expense reporting deadline into this already demanding period will force many filers to rely on estimates rather than finalized and properly reviewed data. The complexity of the reporting itself is another important consideration. The income and expense forms require hundreds of individual data points. In addition, the required rent rolls contain dozens of inputs for every lease within a property. If you've got a big commercial property, between the I&E form and the rent rolls, that could be thousands of inputs that we need to get right. We have to collect it, verify it, and report it accurately. And accuracy is especially important. These forms are signed under oath and submitted under penalty of perjury. Property owners and managers take that responsibility very seriously. Before submission, information is commonly reviewed by multiple parties, including property managers, senior management, accounting teams, property owners, or institutional clients. Each layer of that review helps ensure the information provided is complete, accurate, and reliable, but it takes time. And also note that in our industry, most leases allow the landlords until April 30th to complete the annual operating expense reconciliations. I think that deadline's relevant because it's the product of decades of experience and reflects the practical reality that year-end data collection, reconciliation, and verification take time. In many respects, the proposed March 15th income and expense filing deadline would require information to be submitted before property owners have even finished their other standard year-end financial processes. For these reasons, I respectfully urge you to retain the current April 15th filing deadline. It strikes a great balance between providing assessors with timely information, ensuring that the information submitted is accurate. Thank you so much.
Thank you, Mr. Riley. And Mr. Steinhauser.
Good morning, Mr. Chairman and honorable members of the council. My name is Grant Steinhauser, and I'm a principal on the real property tax team at Ryan LLC. I have lived and worked in the DMV for the past 17 years and spent the past 12 focused on real property tax assessment matters in DC, Maryland, and Virginia. At Ryan, we represent hundreds of commercial and residential property owners in the district, including over 40 billion of assessed real estate value. On behalf of Ryan LLC, I wish to express our opposition to B252 and our support for B484. These bills recognize that the council and Mayor Bowser are serious about addressing the problems in the district's tax code head on, but in doing so, it is important to do no further harm in addressing the situation. B252 would exacerbate the problems faced by taxpayers, while B484 would codify common sense solutions that have proven track records in other jurisdictions. Despite good intentions, B252 will only serve to make existing problems in property tax administration worse by compressing the time assessors have to properly assess complex properties. It will shift administration of incorrect assessments to the Real Property Tax Appeals Commission, or RIPTAC, which is already failing to meet statutory deadlines. Currently, RIPTAC is required by DC Code to issue all decisions by February 1st, so that in theory, a taxpayer can have their appeal decision in hand in advance of the first half tax bill being issued and paid in March. In recent history, RIPTAC has been so overloaded with cases that their docket goes well into February, rendering it impossible for them to meet the 2/1 deadline. In practice, maybe half of the decisions are issued by the 2/1 statutory deadline, and even this week, we are still receiving decisions from hearings that were held over 6 months ago. Compressing this timeline will only make matters worse. Fortunately, there is an alternative that allows the council to enact effective solutions. B4A4 offers impactful, no or low-cost fixes to the district's property tax assessment and appeals process. Here are a few key provisions. One, it allows letters of authorization to remain in force for up to 3 years. LOAs are used for taxpayers to authorize their agents to file an appeal on their behalf. And currently, the district requires that taxpayers provide a new separate signed and notarized LOA every year for both OTR and RIPTAC levels of appeal, so 2 separate LOAs each year. This is overburdensome to both the taxpayer and OTR, who actually has to review thousands of LOAs per year, and allowing more durability will save time and money on both ends, similar to what is done in Maryland and Fairfax County. 2, permitting taxpayers to opt into electronic document delivery. So much of the assessment and appeals process is already administered online, including virtual hearings at all 3 levels of appeal. Yet OTR does not provide electronic delivery for property tax related notices such as first level appeal decisions. Instead, they are mailed via USPS and regularly take up to 2 weeks to reach their destination, if they make it at all. Electronic delivery is a common sense measure that should save the district money on postage and improve the taxpayer's experience as they can receive their decisions in a more timely manner. And 3, specifying the term days in this code refers to business days and not calendar days. This is a simple clarification that will clear up a frequent point of confusion at RIPTAC, where OTR is required to submit their response to an appeal 7 days before the hearing, and the petitioner must submit their rebuttal 3 business days before. If there's a holiday weekend in between, there can be times where OTR's submission and the petitioner's rebuttal are due on the same day, which is obviously not the intent of the code. The district is at a crossroads, and passing B252 would move the district backwards and make its property tax administration system more onerous and chaotic, while B4A4 would streamline property tax administration for both government and taxpayers alike. Thank you for your time, and I would be happy to answer any questions you have.
Thank you. So I do have a few questions. Maybe I'll focus on you, Mr. Steinhauser. So the letters of authorization, that's just simply a letter that says that Phil Mendelson's authorized to represent me in this matter. All right, got it.
Correct.
And then why is it so great to eliminate the 5% rule?
The 5% rule isn't something that exists in Maryland or Virginia or really in other places.
So we're better than them.
I'll give you the example of, a $100 million office building. You appeal, the commission concludes to a value of $96 million. But because it doesn't meet their 5% threshold, you're sustained at 100 million. So you end up essentially overpaying your tax bill by, over $75,000. But then the taxpayer ultimately files to court and gets that money back anyways, plus interest. So why not?
So my house is valued at $100,000. My house is valued at $100,000. I think that's too much. It's actually should be like $95,000 or $96,000. Isn't that kind of stupid to tie up the process?
I wouldn't say so, no.
What's the tax on $4,000? $86 maybe?
That could be important to you. That's a ticket to a game. I don't know.
All right, well, that answers that question. Maybe those are the only questions I had with regard to your testimony. Ms. Castro, moving up the deadline to file I&E reports. The apparent goal of these proposed changes would be to provide OTR with the most recent income and expense data. This is a solution in need of a problem. The current appeal process is structured so that in the context of an appeal, the district has the most recent income expense available. That doesn't strike me as very efficient. So the assessors are going to go off and assess the value of your property, and they get it wrong because they don't have the most recent I&E. And so after they do that, and you have to file an appeal, And then they have to do whatever paperwork, and then you get to bring them at the first level, the current I&E. That doesn't strike me as efficient at all.
Well, the issue is they're not relying on the income and expense forms in the first place. So it's the
They're not?
methodology.
What are they relying on?
They assemble all of this data, and they put it into a database, and they create in their CAMA system the methodology that they're using to value commercial
So
properties.
CAMA is mass appraisal.
Correct.
Makes
And-
sense in a residential context. You're saying they use mass appraisal for commercial property?
Correct. And to emphasize the point, the calendars in Virginia and in Maryland are the same as the calendar in the district, but Maryland and Virginia are able to come up with high-quality assessments with far fewer appeals than the district is.
And why do they come up with,
Because they have better quality processes and methodologies for valuing their properties than the district does.
meaning they don't use the CAMA?
They have their own versions of mass appraisal, but it's better quality, and they rely on better data than the district does.
Maybe, let me just see. Yeah, one other question. Several people brought this up. Ms. Castro, I made the note with your testimony. What's wrong with 2 calendars? I deal with multiple calendars.
I think it would be very confusing to both the taxpayers and the representatives at the district. My example was a property owner that has multiple apartment buildings, and they may have multiple pieces of land, and they want to file appeals. Well, there'd be 2 separate calendars. So there'd be one calendar for the apartment buildings and a separate calendar for the land parcels. So it's already a lot for property owners to keep track of these calendars, and now they're going to have to keep track of 2 different calendars. And on the flip side, that means the folks at the district, Office of Tax and Revenue and RIPTAC, they'll have to keep track of 2 different calendars as well. So I think it's just an administrative burden.
Well, I think the folks at the district they don't see a problem with the 2 calendars. So, and I'm thinking while you were speaking, a landlord, I probably should let it go, but a landlord's got 1,000 apartments and is in the process of evicting 10 people, each of whom's on a different calendar. They're able to handle that.
I can't respond to that fact, so yeah.
All right, Councilmember Bonds?
Thank you, Chairman. In my very short time, I guess I'll just be very general. Can I get from each of the panels a step in the appeals process, aside from the reporting deadlines that you've discussed, but steps in the appeals process that should be changed, whether it's a need for additional staff, elimination of maybe filing paperwork that is required, the electronic record keeping process, and you just mentioned the dual or competing calendars. Give me some thoughts, please, that you may have on that. And we'll start with you, sir.
So currently, we have 4 months for the first level appeals. And often you would want the assessor to come and actually physically see your property for site inspections. It's regular, in other taxing jurisdictions where they'll come see your property. You have the opportunity to show them, hey, this has changed. Our tenant moved out. We're redeveloping it, whatever it is.
All right, so physical assessment.
Right.
All right, Ms. Castro. I only have 3 minutes. Sorry.
I'll defer to other.
All right,
other
anyone
panel on
else?
that one.
Don't be shy.
No, I would say requirements to recognize sales. I mean, that's the single biggest problem right now is we have dozens and dozens of sales across asset classes that the district just continues to disregard. And that's the reason why the assessments don't reflect market value.
All right,
That's what I was going to say.
all right. Ms. Castro, anything? No? Okay, all right. So that's what I was trying to figure out. If we were to, and to make any changes that would be meaningful, what do you see to be the most meaningful changes that need to be done? I think you all have, I think I've heard all day the interest in change that needs to be made in this process. And I guess from my perspective, um, we depend on tax revenue that's generated through the assessed value of the property, the facilities, and the land. So how do we come together on this in order to keep the district moving forward and also to be fair and be real about the circumstances that we're confronting in this new frontier of our country as well as our city? Any thoughts? No? Okay. All right. The other question I have is, I wanted to ask a little bit about Bill 484. Everyone seems to be comfortable with 484, is that correct? You see the merit in that? All right. And with my minute left, do you have any thoughts about how we should handle the assessed value of senior-owned property, residential property, where they are actually the resident in place of property? Have any thoughts about that? I know your commercial interests, but just, you will be a senior one day, What do you think about
I'm an
that?
office guy, right? But I thought the testimony about combining seniors that live together was very compelling. That just made logical sense to me.
Compelling in what way when you say that?
Well, if it's like grandma dies and she's leaving the property to her elderly children, the two children, if they both are eligible, that's like the fact that the ownership split, it still meets the intent as far as I could tell.
All right, okay. And what do you think about a senior being the qualifying resident for reduced property taxes without having to prove that they have 50%? Perhaps they have been negligent in changing the deed. One of the spouses deceased. How do we help them? We currently have the 50% property tax reduction, but that's based on the income of the household. So if grandson is living with grandma and grandson's income far exceeds 100,000, then the senior's not eligible.
My only thought, just thinking of this, is the occupancy of the house, at least as I'm thinking about this, would seem to want to drive where the exemption goes. Because, if the elderly occupant of the house is really going to be the beneficiary of the exemption. And so to me, rather than ownership, it's kind of the occupancy and who bears the burden of the cost. But just to me, like looking at this anew, I haven't focused on this.
Okay.
That kind of strikes me as where you'd want to aim the targeted relief is to the occupant or the tenant.
All right. Well, I'm doing scattered here because we don't have 15 minutes to talk to each of you, but thank you so very much. Thank you, Chairman.
Thank you all.
Thank you, Councilmember. Thank you all for your testimony. Eric Jones is Vice President of Government Affairs at DC for DC Commercial Properties at AOBA. Tony Mancuso, Chair of the DC Public Policy Committee, Greater Capital Area Association of Realtors. Gary Keltz, listed as a public witness. Antonio Myers, listed as a public witness. Robert Vincent Branham. Joseph Bishop Henchman, Executive Vice President, National Taxpayers Union Foundation. I think I'll stop right there. Mr. Jones, Eric Jones is online. Mr. Jones, you're up.
Thank you. Good afternoon, Chairman Mendelson and the members of the Committee of the Whole. I am Eric Jones, a fourth-generation Washingtonian and current Ward 4 resident who serves as Vice President of Government Affairs, DC Commercial, for the Apartment and Office Building Association of Metropolitan Washington, also known as AOBA. Over 50 years, AOBA has represented commercial, office, and multifamily residential real estate in Washington, DC metropolitan area, with members' portfolios totaling over 166 million square feet of commercial space and more than 480,000 rental units in DC, Maryland, and Virginia. In the district proper, our members manage more than 75 million square feet of commercial space and nearly 120,000 rental units. I'm here today to provide comments on B 26-252, the Real Property Assessment and Appeals Schedule Revision Act of 2025, and B 26-484, the Fairness and Accuracy in Real Property Tax Assessments Amendment Act. First, I'll start with the Real Property Assessment and Appeals Schedule Revision Act of 2025. For at least the last decade, based on my internal research, members have voiced concerns, and AOBA has shared its views on the property tax appeals process. Although the agency claims this legislation will streamline the process, reduce inaccuracies, and cut appeals, our members remain unconvinced. Shifting the due date for income and expense reports from April 15th to March 15th is unlikely to achieve the intended goal. An earlier deadline could pressure property owners and accounting teams to compile data based on previous year's close without considering outstanding invoices, final reconciliations, or other essential accounting activities. Furthermore, this change would increase staffing needs at a time when operational demands are already high, given the risk of supplying inaccurate information, which could lead to criminal or financial penalties. We strongly recommend against this change. Additionally, the idea that this would reduce appeals cannot be substantiated. While the agency argues that the information typically included in appeals is part of the calculation, it wouldn't be completed based on previous paragraph. Since this information, which may be inaccurate, has already been submitted to OTR, the appeals process will resemble a legal case, potentially before the understaffed and overburdened Office of Administrative Hearings, or OAH, which would be costlier and likely to lead to similar outcomes. While the ability to provide appeal decisions virtually is appealing, even this could be a topic of concern if the agency has failed to conduct proper due diligence to ensure that all contact information is current. Now I'll turn to the Fairness and Accuracy in Real Property Tax Assessments Act of 2025. Similar to the previous bill, our Government Affairs Committee appreciates the legislature's intent, but remain hesitant to support it. The limited industry participation during its drafting and since its introduction 7 months ago does little to ease the doubts about its need. As an organization, we believe tax policy should not be created in isolation, and this legislation represents exactly that. While we are unfortunately here today to oppose both of the aforementioned legislative items, we appreciate the council and staff for their efforts in addressing these issues and are open to working with any member of the body and their team on a collaborative process moving forward. In closing, I would like to thank you for this opportunity. Really quickly, because I know Councilman Bonds has asked on this, when you talk about the senior housing, I can personally speak that just last year, I, along with two of my elderly aunts, had to sell one of my family homes, which I was co-owner of, because they could not qualify as dual owners. And because of that, prior to selling it, the tax burden fell strictly on my wife and I to take care of an additional home, which we could not always do. After a long period of time, it just became unsustainable based on the need of the home, and things like this are why I think that is a great idea that you previously mentioned. With that, I thank you for the time.
Thank you, Mr. Jones. In your statement, you said a reference to the appeal process would resemble a legal case potentially before the understaffed and overburdened Office of Administrative Hearings. Did you mean OAH or did you mean the Real Property Tax Appeals Commission?
OAH, because from our understanding, if you actually get past the RIPTAC process, which this bill would possibly create, it would then go to OAH.
I'm sorry, you're saying tax cases go to OAH?
After RIPTAC, yes. Based on the comments of several of our members. We had several lawyers and other members who said after the RIPTAC process, if you still wish to appeal, and I'm basing it on that information.
All right. Thank you. Tony Mancuso.
Afternoon, Chairman Mendelson,
Good
Councilmember Bonds. My name is Tony Mancuso. I'm the Chair of the Public Policy Committee for the Greater Capital Area Association of Realtors. GCAR and our 11,000 members are the leading fact-based and collaborative voice for real estate professionals, small housing providers, homeowners, and renters who live and work in the District of Columbia and Montgomery County, Maryland. Our testimony today centers around the support for B-26-476, the Disabled Veterans Complete Property Tax Exemption Amendment Act. When we evaluate legislation, sometimes review of the specifics requires extensive discussion and debate. In the case of this bill, after the specifics of the legislation were shared, unanimous support was reached in less than a minute. Currently, the district Class 1A residential property is taxed at 85 cents per $100 of assessed value. As an example, if a disabled veteran has a home valued at $500,000, their property tax bill would come out to $4,250 each year. For some, this may be manageable, but for those with limited abilities to work or for those who are on a fixed income, this tax bill may lead to serious implications on their ability to afford basic necessities, care of loved ones, pay for repairs to their home, et cetera, et cetera. Those who have served our country, especially those who sustain disability as a result of their service, deserve relief and support wherever possible. This legislation will go a long way to help minimize the financial burdens that our disabled veterans have to account for. Washington, D.C. is filled with monuments that honor men and women who have served our country. Making D.C. affordable and supportive of veterans who call the district home is just as important a testament to their legacy as the monuments that remind us of their service and sacrifice. We urge the committee to support this legislation unanimously, and we appreciate the opportunity to share our association's perspective and are eager to answer any questions the committee may have. Thank you for your time.
Thank you, Mr. Mancuso. Gary Kells?
Good morning, and thank you for allowing me to speak today on 26476. My name is Gary Keltz, and I'm a U.S. Air Force Gulf War era 100% service-connected disabled veteran. I suffer from chronic respiratory illness due to toxic exposure, PTSD, as well as other issues. I served proudly, I took my oath seriously, and I prepared to put my life on the line for our country. I moved to the DMV nearly 11 years ago. I chose to live in Maryland at that time because Virginia and Maryland both have property tax exemption for 100% disabled veterans. There are 21 states, in fact, that offer that benefit. In 2023, I decided I really wanted to live in the district. I made the decision to move here. I love living in Washington, D.C., and I'm a resident to be here. Housing expenses have gotten out of control in the district. I believe if this bill is passed, veterans that live in the DMV areas would likely make the decision to move into the district. This would also boost the local economy as well. This year, I purchased a home here in the DC. The price of my home with current mortgage rate makes a large monthly payment. Making housing more affordable needs to be a top priority in DC. I'm asking you to please vote yes on this bill and let's make DC appealing to our veterans. I'd like to thank Councilmember Brooke Pinto for sponsoring this bill, Councilmember Janice Lewis-George for co-sponsoring, and thank you again for allowing me to have a voice in our community. Together, we can build a better Washington, D.C.
Thank you, Mr. Kelson. Thank you for your service. Antonio Myers? Not here. Robert Vincent Branham?
Hello, again, Chairman Mendelson and Councilmember Bonds. And first, let me thank my two colleagues for their service. I am President Emeritus of the DC Federation of Civic Associations, and I am also a military service-connected disabled veteran. I support the legislation dealing with disabled veterans tax exemption. However, I would like to recommend a modification to the legislation that veterans, disabled veterans, service-connected disabled veterans who do not have 100% disability don't benefit from this legislation. It is my request that it be adjusted to the percentage of disability that the disabled veteran has been determined to be. Our service should not be distinguished by the degree of disability. If the intent of the legislation is to honor disabled veterans, all service should be recognized, as opposed to unless you are 100% disabled, you don't get the benefit of being of the tax exemption and the recognition. So I would urge the council to amend the legislation and the law as it currently is to make it applicable to the percentage of disability, the service-connected disability of the veteran, and to make it transferable to the spouse. Thank you.
Thank you, Mr. Brown. I don't have any questions for you all. Let me turn to Councilmember Buns. Who am I forgetting? Oh, Mr. Henchman. I'm sorry. That's because I have to turn the page. I'm sorry.
No problem. Thank you, Mr. Chairman and Councilmember Bonds. Good afternoon. My name is Joseph Bishop Henchman, and I'm here in my capacity as Executive Vice President of the National Taxpayers Union Foundation here in Washington, and of course, a Washington, D.C. resident. No one is more optimistic about the city's economic future than property tax appraisers, as homeowners know when they get their appraisal in the mail. I'm speaking today with comments on B-26-252, but primarily on B-26-484. On 252, I'd just like to echo the comments made by some of the previous witnesses that the calendar and procedural changes in the bill are a solution in search of a problem. There are difficulties with the property tax appraisal and appeals process, but the bill doesn't effectively address many of them, especially with income producing properties. And I'd especially compliment the testimonies of Ms. Castro and Ms. Wadlington for offering constructive solutions in that, and love to see the bill go more in that direction. On B-26-484, I want to praise Councilmember Pinto's introduction of it and the provision to remove the 5% yo-yo, restricting appeals unless they are at least 5% above the or below the appraisal. As someone previously noted, this provision exists nowhere else. Got the Westlaw search in front of me. It's a DC only provision. And I get that that's not necessarily the end of the argument for you, Mr. Chairman, but I did want to put some numbers on it, especially since I have my appraisal in front of me here, my assessment in front of me here. Average home in the district right now is about $700,000. 5% of that is $35,000, and then you apply the property tax rate and you get $297. So that's the rub for a lot of people. And just taking mine for instance, where my appraisal came back, or my assessment came back 9% above market value of what it really should be. If I appeal it, which I am, and there's a meeting in the middle, as sometimes happens in adjudicatory bodies, well, that would be 4.5%. And actually I lose completely then, because it's not above 5%. And then there's an opportunity then to go to court, which is not restricted by this 5% rule, and then I win in court. So if the goal of this is to avoid unnecessary process and expense and burden, I don't think it's achieving that, and that's a reason why it's not in the recommended appeal practices from our organization. It's not in the recommended governmental practices from the bodies that assign those, including the Lincoln Institute for Land Policy. It's a thumb on the scale in what is supposed to be a fair and even-handed process, and I'm hopeful that the committee looks favorably on that particular provision. Thank you.
Thank you. Sorry, I overlooked you, but I don't have a copy of your statement. You'll provide that?
I'll provide it. Thank you.
Great. Councilmember Bonds, do you have any questions?
Yes, thank you very much, Chairman. I want to just talk a little bit about this idea, this concept that you put out into the public domain, Mr. Henchman, and that is the thumb on the scale. I think when we talk about tax policy, we're putting the whole hand on the scale. for obvious reasons. And so just can you help the public that may be listening to understand the harm, the hurt when we put our thumb on the scale, given that this is the mechanism by which we fund many and all of government's programming that we do primarily?
Sure, I'll try. So my organization, National Taxpayers Union Foundation, we put out a property tax appeal guide, not just for DC, but for our members all over the country. And it's certainly a harrowing process. It's not an easy one. It's not designed to be an easy process because we don't want lighthearted or frivolous appeals, but we want to get it right. I think government wants to get it right. Taxpayers want to get it right. And you know, I've never met somebody who's excited about paying their property tax, but I think a lot of people understand that it's how we pay for schools, it's how we pay for police, it's how we pay for all of the important services that we need. And we like to talk about our tax system as a voluntary one, and by that we mean we rely heavily on people self-reporting, on people self-complying, on people doing the right thing. And when you have rules like this, where it's not about getting it right, it's if the government is right plus 5%, the government wins, you do harm to that, encouraging people to comply voluntarily. And it's cumulative, it's hard to measure, I get that, but the lodestar for RITPAC and for this process really should be what's the right answer, not what did the government say plus 5%.
Thank you. Thank you very much for that. Very quickly, Mr. Keltz and Mr. Brennan, both veterans, not only thank you for your service, I want you to now talk to us a little bit about disability and how you see it, because the idea is that this bill will help our veteran community. But when we talk about whether you have to be 100% or 50%, are we slicing the melon a little too much? I know we're talking about money. So, and that's so very important, and money that can help with, as you mentioned, Mr. Hinchman, the various programming that we have to do as a government. But where do we draw the line?
Well, I can modify my comment and recommendations to simply say, just eliminate the percentage requirements. It would say, if you are a disabled veteran certified by the VA, then you're eligible for the exemption, regardless of percentage. But I think that you say that you have to be 100% determined disabled veteran, I think disenfranchises other able, other deserving veterans from the benefit.
All right, Mr. Keltz.
I am basing my information on what other states do and what the DMV as a whole does, which is 100% disabled. I believe very strongly in it. I believe in getting this equitable across the country. There are 21 states that currently do it. There are some that do make alterations by your percentage, and I think you have to usually be 30% or more. I'm not sure. I don't have the facts on that. I'm basing my testimony on 100% disabled.
All right, well, thank you. As it relates to residency, you know, it's very easy to be someone who is a veteran who's acquired a very interesting, varied portfolio of properties. Okay, so now as the owner, there's the cost of property taxes. Are we talking about the veteran living in the premise that would see the tax reduction?
Absolutely. It needs to be your primary residence.
Okay, primary residence. All right. And that would be the same for the spouse?
It does carry to the spouse as well.
Okay, I just want to make sure that we're all talking the same thing. Thank you, and thank you for buzzing me. Thank you very
Thank you,
much
Councilmember
for your,
Barnes.
thank you very much for your
Thank you, each of you, for your testimony.
testimony.
And thank you, Mr. Jones. The last group of witnesses before we turn to the government, Brandon Scott, who's Chair of the Public Policy Committee, DC Association of Realtors. Claudia Roca, who is member of the Public Policy Committee, DC Association of Realtors. Shaneri Hubbard, who's President and CEO of the DC Chamber of Commerce. Online. And Benjamin Fillon, who is listed as a public witness. You're up.
Good afternoon, Chairman Mendelson. My name is Brandon Scott, and I'm the chair of the Public Policy Committee for the DC Association of Realtors, or DCAR. I am also a resident of Ward 7 and a professional realtor at Keller Williams Capital Properties. Now, DCAR is the District State Association of Realtors and serves as the premier voice of real estate in DC. Now, our mission is to protect and promote the interests of our approximately 2,800 members and their clients who live and work in every ward of our city. Now, through our advocacy, we represent the real estate professionals, small housing providers, property managers, homeowners, and renters. So I'd like to thank you for the opportunity to testify today, and I'll be speaking on B 26-484, and my colleague, Claudia Roca, will testify on the legislation supporting seniors and disabled veterans. Now, the Fairness and Accuracy of the Real Property Tax Assessment Amendment Act is intended to help stabilize our commercial real estate market and revitalize downtown. We support that goal. However, after consultation with both the administrative agencies and the proponents of this bill, we ask that the elements of the bill be narrowed in scope to address the problems that it is trying to solve. At the outset, we have no objections to 4 provisions of this bill, namely extending the effective period for letters of authorizations, standardizing appeals filing deadlines to business days, extending the deadlines for decisions to prior year appeals to March 1st, and allowing electronic delivery of appealed documents. Now, these provisions are largely non-controversial and make a lot of sense. However, we believe that eliminating the 5% rule for adjusting a property's estimated market value would not be beneficial in the residential market. Smaller residential properties have not experienced the same decline in property values as commercial properties, and modest percentage adjustments would not result in meaningful tax savings on typical homes. On the other hand, eliminating the 5% rule for single-family homes and smaller residential properties would likely encourage a higher volume of appeals for relatively small dollar amounts, leading to backlogs and delays at the Real Property Tax Appeal Commission. Now, these delays will cause real harm for homeowners with more serious assessment concerns. Now, in addition, updated market data obtained during the pendency of an appeal for smaller residential properties could result in an increase in taxes for homeowners who appeal their valuations. Now, to avoid these harms, we recommend that any elimination or adjustment of the 5% rule be limited to commercial and mixed-use properties, as defined by the property class and zone. Similar, we are concerned that accelerating the decision timeline for complex commercial cases to 30 days would require additional capacity at RIPTAC. Without substantially more resources, we are worried that attempting to accelerate this timeline would also increase pressure on the appeal system. Now, with those 2 issues addressed, we would support the legislation moving forward. I would like to thank you, Chairman Mendelson, and I'll be happy to answer any questions that you have.
Thank you, Mr. Scott. Ms. Roca.
Good afternoon, Chairman Mendelson and Councilmember Bonds. My name is Claudia Roca. I'm a member of the Public Policy Committee for the DC Association of Realtors, or DCAR. I'm also the director of the Cooperative Division for Monarch Title, and I work here in the district, including in properties wards 2 and 6. Thank you for the opportunity to testify. As my colleague Brandon mentioned, I'm here to share our support for the Senior Tax Aggregation Amendment Act and the Disabled Veterans Complete Property Tax Exemption Amendment Act. DCAR submitted letters in support of both of these bills since they were introduced, and we appreciate moving them to a hearing today. B 26360, the Senior Property Tax Aggregation Amendment Act, would support seniors who want to age in place in the district and prevent unnecessary foreclosures. Current law allows seniors a real property tax deduction if they individually own 50% of a residential property and their household meets certain income requirements. The challenge arises when a family property is passed to multiple heirs or owned collectively by more than 2 seniors. This legislation would allow seniors to aggregate their ownership stakes and ensure they receive the tax relief they would otherwise be entitled to. As you consider this legislation, we ask you to also consider raising the current income limit to receive senior property tax relief. The current household income limit of $159,750 leaves many residents at real risk of displacement, foreclosure, or difficult choices between paying taxes or paying for other necessities. As more seniors choose to live together to manage increasing costs, the household income limit for the senior property tax deduction will impact more households over time. The Disabled Veterans Complete Property Tax Exemption Amendment Act would build on earlier reforms to extend a complete homestead deduction for the homes of qualifying disabled veterans and their surviving spouses without existing limitations related to household income or home value. Adopting this reform would align with the district's benefits more closely with the approaches taken in Maryland and Virginia, reducing the risk of displacement for veterans and their families. In addition, program administration would be significantly simplified by eliminating current eligibility requirements based on arbitrary income and property value limits. Removing restrictive eligibility requirements would reflect recent increases in both home values and area median income in the district and ensure the program remains a viable benefit. Perhaps most importantly, this legislation reflects the fact that disabled veterans have already paid more than their fair share for the security and well-being of the district. Extending this benefit is the least we can do to recognize their service. Thank you, Chairman Mendelson and Councilmember Bombs. I'll be happy to answer any questions you may have.
Thank you, Ms. Roca. Shaneri Hubbard, I believe, is not here with the Chamber of Commerce. Benjamin Fallon.
Good afternoon, Chairman Mendelson and Councilmember Bonds. I want to thank you for the opportunity to testify in support of Bill 26-0476, the Disabled Veterans Complete Property Tax Exemption Amendment Act of 2025. My name is Benjamin Fallon. I proudly served in the United States Army for 22 years and have been determined by the Department of Veterans Affairs to be 100% service-connected, permanent, and total. I've lived in the District of Columbia for 7 years. About 6.5 of those years I rented in different areas of the city. And earlier this year, I made the decision to use my VA home loan benefit to purchase my first home, my very first home here in the district, Ward 2 in the Shaw neighborhood. I'm originally from Texas. Financially, it would have been easier to buy a home in Texas or just across the river in the Commonwealth of Virginia, because both provide a full property tax exemption for veterans with permanent and total service-connected disabilities. Instead, I chose to stay in the district because I believe in this city. I built my life here, continuing my career supporting the Department of Defense, and invested in this community by purchasing a home. There's one point I hope you remember today. Permanent and total does not mean my service ended. It means the injuries from my service never will. Many veterans with permanent and total disabilities continue working, paying taxes, raising families, and contributing to their communities. We are not asking for charity. We are asking the district to recognize the lifelong sacrifices that earned this designation. That is why Bill 26-0476 is so important. The bill removes the current household income restriction that prevents some permanently disabled veterans from qualifying for property tax relief simply because they continue working after military service. It also replaces the current partial exemption with a complete exemption and extends that protection to eligible surviving spouses. This bill is about more than property taxes. It is about housing stability, financial security, and honoring veterans whose service resulted in permanent lifelong disabilities. The district would not be standing alone by passing this legislation. States with very different political priorities, such as my state of Texas, the Commonwealth of Virginia, and most recently, the state of New York, have all concluded that veterans with permanent and total service-connected disabilities should have full property tax relief. I chose Washington, D.C. as my home. Today, I respectfully ask the district to demonstrate it values veterans who have chosen to invest their lives here. Bill 26-0476 is a thoughtful, targeted measure that removes an outdated barrier and strengthens the district's commitment to those who have sacrificed the most. I respectfully ask that you pass Bill 26-0476. Thank you for your time, your consideration, and your continued support for our nation's veterans.
Thank you, Mr. Falon. I just have one question for you, Ms. Roca. With regard to the senior citizen tax relief, you argue that the $159,000 threshold or ceiling is unfair. Our thinking is that we don't need to be providing real property tax relief to people who have the ability to pay their taxes. A household income of $160,000 annually seems like it's more than adequate. So explain the thinking.
The 159,750 looks adequate for just the property taxes, but with the rising cost of everything else within the median income and like I said, the rise in paying for electric, water, and all that, when you look at the total cost of that household, the 159,750 is really not a good marker for a total household income. This is kind of bare minimum what they're getting from either their benefits or something else. So it would really trigger paying for housing costs or paying for groceries at that point, if you look at the actual cost of living in the District of Columbia.
Interesting argument. It is indexed to inflation, so it goes up.
Understood, but most of the benefits that a senior citizen gets don't include, as I said, I understand you're thinking of just housing costs, which is one item. It would probably make them tight on making anything, or if there's a repair in the future, it would put them at a disadvantage for any emergency that comes up. It looks, like I said, potentially if everything is perfect, it looks like the budget balances. But again, these seniors, if there is an issue with the roof or a boiler or something of that nature, they won't have the reserves to pay that and then all their housing other housing costs.
I'm going to turn to Councilmember Bonds. Councilmember Bonds, do you have questions?
Yes, thank you very much. And thank you, panel, and thank you, sir, for your service as well. On the senior property tax relief, a few years ago, I attempted to remove seniors of 70 years of age from paying property taxes in this city. And the chairman decided, well, everyone pays property taxes, so it became a deferred program. And the original interest rate for a deferred program was about 6%, which is, as you know what that means. Over the years, we have thought about how we could move the needle again. So it's not just veterans, but it's also longstanding seniors who really help to make this community what it is, so that my children and grandchildren can say that they want to live here, okay, as yours as well. And I say all of this to say, I wonder if you have the thoughts and the stomach for where I think we need to be now. If a senior's income is, let's say, under 50,000, most of them, their income is really under 30,000, to be honest with you, in the District of Columbia. But they are in properties that they purchased many years ago as a retiree from the federal government on a very limited income, but they were able to buy a home for 12,000 that's now valued at 800,000. So that means their tax is up. Yes, they currently, if they live alone or their income for the household doesn't exceed 159,000, they have the opportunity to get 50% reduction. But 50% reduction on that value of a home, you see they still have to pay thousands. So I wonder if we're at a point where we need to create a tiered approach to property taxes. So the lower income pays maybe 10%, maybe the middle income of that, as we go up, getting closer to 159 or 175, would pay maybe 25%. And in other words, thinking about how we might make an adjustment so that this is a community that welcomes everyone. So it's not one group of citizenry versus another if you are a property owner. What do you think about that, Ms. Rocco?
Although the idea actually does have a lot of appeal, how my thought is more, how would that procedurally work in a tiered system? How does that get implemented? Who's to unpack it? Who's to process? Who's to police? So I understand the intent, but putting in a program where is it an arbitrary system and is it self-reporting? You know, there's a lot of nuance to proposing something of that scope. Though in its spirit, I think it's a good idea.
Okay, well, thank you. Thank you. Mr. Fellon, you want to comment on that?
I can only comment it in reference to the 0476 about the disability and hearing the earlier testimony about it. I think there is a very distinct difference between being 100% disabled and 100% disabled permanent and total. Those are two separate and different things. A veteran can be 100% disabled, but the VA says, hey, you know what? You have an opportunity to improve from your injuries. You're still 100% disabled, but you have the opportunity to improve.
All right.
The permanent and total comes in when the VA decides there's no more we can do for you. Good luck. Your injuries will probably continue to progress as you get older. So there's the distinct difference there. And I think some people get that mixed up. And I'm just trying to go with what the VA states.
All right.
And when we're talking about household incomes and, limitations on that, sorry, I'll wrap it up here in a minute. We're talking about aligning a legislation with money, and the VA doesn't do that. The VA is aligning their disability ratings with your injuries.
All right. Well, I thank you very much for that. Mr. Scott, the question is still on the table. Do you have some thoughts? I asked Ms. Roca, do you have some thoughts about the senior ideas that I projected?
With respect to the senior tax, I think there's definitely room, I think, for larger consideration. I think the low-hanging fruit creates an opportunity, as Ms. Roca talked about, which is creating space for more seniors to be able to live collectively together. I think if we are looking at what the tax benefits look like around that, so if there was an adjustment from the 159 or 160 price point, that created considerations for seniors that lived in the community or in a house together, there may be more opportunities, I think, to create a gateway to explore what those opportunities look like.
I appreciate that comment, but surely you are not suggesting that only if seniors live together should they have a tax benefit.
No, I think that's just one part of it. I think that's one
Okay.
pathway to be able to create
All right.
broader discussions around how do we begin to tackle the
see.
opportunity for taxes.
You
around
will be a
seniors.
senior one day, you know that.
God willing, and the
Okay.
creek don't rise.
If
Yes,
you're
ma'am.
lucky. Thank you very much. Thank you very much to the panel. Thank you, Chairman.
Thank you, Councilmember. I have no further questions. Thank you, each of you, for your testimony. We're going to turn now to the government. We have three. And again, I want to apologize. I had suggested that PIPTAC would not be here. Robert Cooper is participating virtually. He's Vice Chair of the Real Property Tax Appeals Commission. Robert McKean, who is Deputy Associate General Counsel at the Office of the Chief Financial Officer, and Basil Facina, who is Assistant General Counsel at the Office of the Chief Financial Officer. And what I'm going to do, because I have lots of statements from y'all, is go through all of your testimony, and then I'll ask questions. And if Councilmember Bonds is still here, she'll ask questions as well. So Mr. Cooper, you're first, and thank you for being here.
Thank you. Thank you, Chairman Mendelson. Good afternoon to you and to members of the committee. My name is Robert Cooper. I am Vice Chairman of the Real Property Tax Appeals Commission, and I bring greetings from our Chairman, Mr. Trent Williams, and the other professionals that make up our commission and staff. We thank you for this opportunity to testify on both of the bills before you, Real Property Tax Appeals Assessment and Appeals Schedule Revision Act 252 and the Fairness and Accuracy of Real Property Assessments Amendments Act, which is Bill 484. As you know, RIPTAC serves as the second level real property appeals body and determines whether the Office of Tax and Revenue had erred in its property assessment. So not unlike other appeal bodies, our body looks to see if there was an error. Now there's an assumption of accuracy coming before us. It is presumed that the assessments before us are accurate. So our goal is to listen to the evidence and testimony presented and determine if there was any error made on the part of the Office of Tax and Revenue. So as to these bills, I think generally there's some support for them. Anything that will advance accuracy, anything that will advance the speed of processing these accurate decisions is welcomed. But we believe that under 484, there are a few of the amendments that we believe may hamper, in fact, the productivity of the commission, specifically changing the end of our second level appeal season to March 1st of each year. Though this does give us additional time on the back end, it directly may ultimately impact OTR's ability to timely notify property owners of their annual assessments and then their ultimate ability to file in the next level of appellate level, which is the courts, and it could severely impact the entire appeal season. Another concern is obviously a change to electronic submissions of appeals. Now, there was some discussion about whether it was the entire appeal process or only electronic submissions between the petitioners and Office of Tax and Revenue. Most petitioners, residential, commercial, small, large buildings, warehouses, and the like, vacant property, have adopted the online portal, which is our File and Serve Express portal for the filing and submission. You have to understand that there are often hundreds of pages of documents submitted by the parties with photographs and the like, and it could conceivably bog down an email system. If this is pertaining to filings and submissions with the commission. Our staff is relatively small, and I can get into that into questioning, but we believe that having a central database where all parties, all stakeholders can have access to review, submit, and also determine timeliness of filings and completeness of filings, makes this process a bit more simpler and is easier for everyone to access. Expanding this to email submissions with clutter inboxes and could cause other problems where parts of the emails may not make it. There are deadlines for submissions, and again, if the emails are then submitted to our staff, then our staff has to then package them and submit them into the appropriate places. And as I said, I can get into our staffing issues in a little bit. Finally, the elimination of the 5% rule will increase RIP-TAC's caseload and hearing volume, which would have downstream impact on administrative processing times dramatically. The 5% rule, again, I can get into this with questioning, but the 5% rule aids in frivolous, I don't want to say frivolous, but cases where someone says, as you said, Chairman Mendelson, if somebody wants a $100 reduction, and that equates to about 45 cents tax, but we're spending multitudes of hours of time for both the Ultimates tax and revenue to set it for hearings, our staff, our decisions that we have to issue. And the majority of this 5% rule issue, again, whether the assessments are accurate or not, the goal is accuracy, but we have to determine whether there was an error. So there has to be some leeway for the Office of Tax and Revenue to say, it's in this area. It's not down to the penny. And so if someone wants to come in and argue pennies, then they would have the right to do so. And it could bog down the system. And there are other issues that we can address on questions and when you get to a question and answer session. Under 252 seeks to administratively modernize and improve the accuracy of assessments. Our RIP-TAC understands this bill would allow additional time to submit income and expense reports and other relevant documents, facilitating an accurate and timely assessment. Generally, obviously, anything that assists and aids in creating accurate assessments. Now, accurate doesn't necessarily mean acceptable to a petitioner. And again, most of these cases, the vast majority of cases don't fall anywhere near a 5% issue. It's dramatic reductions that petitioners are requesting. So I think obviously if OTR needs more paperwork, more certifications, I think there are challenges that have been expressed by the property owners in the industry. I think is accurate. Timing of these things but at some point, deadlines have to be met, and we have to determine what deadline is appropriate and whether or not the parties can actually meet those deadlines. So just a few other quick points. Having heard the testimonies from numerous stakeholders today, over the last 5 years or so, RIP-TAC has handled on average about 5,900 cases. And those are cases from Office of Tax and Revenue on appeals. It's also cases from Department of Buildings, vacant property, blighted property. Some of the cases dealing with the seniors. We handle all of those with 6 full-time commissioners. And we can get up to 8 part-time commissioners. We actually have only 2 full-time administrative staff persons that handle all of the paperwork. That's reviewing every piece of paper that comes in, making sure that it's categorized in the hands of the commissioners, and the scheduling of the cases. And that scheduling is very intensive, dealing with both the petitioners and the Office of Tax and Revenue, providing us dates, calendaring, making sure we have adequate support for those hearings. Most of us are on panels 3 days a week, and each day we could be subjected to hearings between 10 o'clock in the morning until 5 o'clock in the evening. And that means that each of us may have 5 to 6 cases to decide and write, and we're right back at it again the next day. So, and then of course we have one full-time IT person who aids us, and he's working on both panels each day making sure that our hearings are recorded, that we all have our documents, and that everyone is able to communicate properly. Obviously, the remote hearing system works. And we have our great executive director who sort of watches over and manages all of us and makes sure that legislation is presented to us and that we have opportunity to meet publicly and also do things that we can into the community, ensure that people understand that they can in fact file appeals and how the appeal process works. So for our residential cases, single family, small buildings, our decisions we're obligated to render our decisions in 30 days, 80 days for commercial residential buildings of 5 and more. Over the last year, so this last year, 59% of all our cases were decided by the February 1st deadline. Now you may say, well, that's wholly deficient when we are obligated to be 100%. But you got to understand, we're still hearing cases in February. We were hearing cases in late February, beginning of March. So the number of cases was so great this year that we were still hearing cases well after the deadline. 83% of all the commercial cases were decided within the 80 days that were permitted under the act. So we're doing a yeoman's job. Is it perfect? Did we meet all of our obligations? No, absolutely not. But if we're still hearing cases in March, there's no way we can have all our cases wrapped up by February 1st. It's impossible. And again, staffing, I'm sure in our submissions to the council, we need more staff. Our technology is what it is. It could use upgrades. We've got some printers that don't work, copiers. We've got issues, but we're making it work. But our staff is overworked, and by creating a situation where this 5% rule is eliminated, and you also have to remember, other jurisdictions only do their assessments every 2 years. The Office of Tax and Revenue is working hard. They're producing assessments and reassessments every year. So they can't get out to every property and see every property. There are not enough OTR representatives and assessors to do that level of work. But I think overall, anything that the changes in the laws and regulations to create accuracy, I think there were some great points made by some stakeholders today about the appraisals and capitalization rates and those types of things. But all of those cases come to the commissioners, and we're obligated to listen to all the testimony. And remember, each case takes about a half hour to 45 minutes. So if we have large complexes with multiple lots, multiple properties, we hear all of those, and we usually have 2 panels going each day. So I will be willing and able to answer any questions posed of me, as I'm standing in for our chairman, but I'd be happy to answer any questions when the time comes. Thank you.
Thank you, Mr. Cooper, and thank you for being here. I will have some questions, but let me turn to the other 2 witnesses. Is it Mr. McKeon?
McKeown.
Please proceed.
Okay. This is on Bill 484.
I think you're testifying on everything. Here on everything.
Okay. All right, I'll start with the low one, 252. Good morning, Chairman Mendelson and members of the Committee of the Whole. My name is Robert McKeown. I'm the Deputy Associate General Counsel in the Office of the Chief Financial Officer. I'm pleased to testify for the OCFO on Bill 26-252, the Real Property Assessment and Appeals Schedule Revision Act of 2025. As you are aware, owners of income-producing properties frequently appeal real property assessments alleging that the Office of Tax and Revenue valued the property based on stale income and expense information. Currently, assessments are derived from income and expense information accumulated 2 calendar years prior, which does not necessarily account for current market conditions. The bill would provide OTR with the means to base its assessments for income-producing properties on the latest income and expense information available from the immediately prior calendar year. By advancing the data available, OTR's assessments will account for the latest market dynamics, including changes in vacancy, rents, and expenses, and utilizing the latest derived capitalization rates. To achieve the aforementioned objectives, OTR would publish a listing of those properties that must file income and expense forms. The income expense statement filing due date would be advanced per the bill as introduced to March 15th rather than April 15th. Assessment notices for those affected properties would be sent by June 1st rather than March 1st, and the first level appeal deadline would be July 1st rather than April 1st. Appeals to the Real Property Tax Appeals Commission would be extended by 15 days, and the time frame for RIPTAC to render decisions would be similarly extended by 15 days, resulting in no change to RIPTAC's overall allotted time for rendering decisions. The bill also allows OTR to provide responses to RIPTAC via electronic communication and for RIPTAC to adjust rehearing panels in the event of a leadership vacancy. The bill was first introduced over a year ago, and OTR requests that the applicability date of the bill begin with annual assessments made on or after January 1, 2028, which would be effective for the tax year 2029 annual assessments to allow for sufficient time to implement this change. Thank you for the opportunity to testify. This concludes my testimony, and I am happy to answer any questions you may have at this time. And I'd also like to note that OTR is very willing to work with stakeholders to address any concerns that they may have.
So do you want to go to your next statement, or should I turn to Mr. Ficina for 360 and then back to you for 476? How do you want to do this?
We can alternate, sure.
Okay.
I'm happy to deliver the testimony on 360. Good afternoon, Chairman Mendelson, members of the Committee of the Whole. My name is Basil Ficina. I'm an Assistant General Counsel in the Office of the Chief Financial Officer, and I'm pleased to testify for the OCFO on Bill 26-360, the Senior Property Tax Aggregation Amendment Act of 2025. The bill changes the property ownership requirements for the senior citizens and disabled real property tax deduction under DC Code Section 47-463. This deduction allows a 50% reduction in the real property taxes imposed on qualifying residential property. Currently, to qualify for this benefit, a residential property must be at least 50% owned by the senior citizen or disabled individual applying for the benefit. The bill would change this rule to provide that the applicant need only have an ownership interest in the property, which could be less than 50%. The bill provides that for senior citizens, individuals residing in the property, including the senior citizen applicant, must own at least 50% of the property. These other individuals do not need to be senior citizens. Accordingly, a property could qualify for the deduction even though a senior citizen owns only a small interest in the property. Similarly, the bill eliminates the 50% ownership requirement for the disabled deduction, and so a property could qualify for this deduction even though a disabled individual may own only a small interest in the property. As a result, the bill would substantially broaden eligibility for these benefits and would not require that the benefit of the deduction be primarily given to senior citizen or disabled property owners. If it is determined that the bill should simply allow for the aggregation of ownership interests of senior citizens or disabled individuals, suggested language to accomplish that objective is attached to my testimony. Thank you for the opportunity to testify. This concludes my testimony, and I'm happy to answer any questions.
Thank you. So I think the next bill is 476.
Yes. Good morning, Chairman Wilson, members of the Committee of the Whole. My name is Robert McKeown. I'm the Deputy Associate General Counsel in the Office of the Chief Financial Officer's Office of Tax and Revenue. I'm pleased to testify for the OCFO on Bill 26-476, the Disabled Veterans Complete Property Tax Exemption Amendment Act of 2025. The bill would provide for 100% real property tax exemption for a home owned by a veteran who is wholly disabled as a result of service in the armed forces. The benefit will apply to the home subsequently owned by a surviving spouse. Additionally, the benefit will apply in the instance where the home is owned by a veteran who died in the line of duty or was shortly thereafter acquired by the surviving spouse who was domiciled in the district, or the veteran was so domiciled as of the date of the veteran's death. The income threshold applicable to senior and disabled tax relief is removed. Suggested language to clarify the complete veterans exemption legislation is attached to my testimony. Thank you for the opportunity to testify. This concludes my testimony, and I'm happy to answer any questions that you may have at this time.
Thank you. And 484? I think that's where you wanted to start. Maybe I'm wrong.
Right. Good morning, Chairman Wilson, and members of the committee of the Committee of the Whole. My name is Robert McKeown, the Deputy Associate General Counsel in the Office of the Chief Financial Officer. I'm pleased to testify for the OCFO on Bill 26-484, the Fairness and Accuracy in Real Property Tax Assessments Amendment Act of 2025, pertaining to letters of agent authorization, appeals decision thresholds, and electronic correspondence. The bill would provide for a letter of agent authorization analogous to a power of attorney between the property owner and its tax representative, allowing the tax representative to represent the property owner before the Office of Tax and Revenue and the Real Property Tax Appeals Commission. Once executed, an LOA is valid for 3 years unless revoked or the property is transferred. The current LOA used in real property assessment appeals matters is tax type and tax period specific, as is the case with any power of attorney in tax matters. And this legislation does not elaborate on whether the LOA could apply to subsequent or prior tax periods or multiple tax types, for example, homestead deduction, senior citizen tax relief, income tax, franchise tax, sales tax, employment tax, and personal property tax. Additionally, under this legislation, the LOA would not be required to be notarized. To limit the applicability of the LOA in this bill to real property tax assessment appeals, DC Code Section 47-825.01A, applicable to assessment appeals, should be amended in the Uniform Power of Attorney Act. The bill also would eliminate the longstanding 5% rule where RIPTAC is limited to adjusting assessments in those instances where the change would exceed 5% of the assessment under appeal. Additionally, the bill would change the deadline date for RIPTAC to make its decisions from February 1st to March 1st. The delay in closing the assessment appeals season will cause delayed billing and a significant postponement in tax revenue receipts at OTR and may create other related challenges. The bill purports to provide for electronic communication if requested by the property owner. However, the bill would amend the provision related to non-real property tax appeals, which is inapplicable to real property tax assessment appeals. OTR would suggest that the council consider making such amendment to DC Code 47-804 applicable to service of notice with respect to real property tax matters. OTR is ready to assist the committee in providing draft language that would implement the intent of the council. Thank you for the opportunity to testify. This concludes my testimony, and I'm happy to answer any questions you may have at this time.
Okay, thank you. We have Bill 26-564, I think is next.
Good afternoon, Chairman Mendelson and members of the Committee on the Whole. My name is Basil Fashina. I am an Assistant General Counsel in the Office of the Chief Financial Officer, and I'm pleased to testify for the OCFO on Bill 26-564, the Food and Friends Property Tax Exemption Amendment Act of 2026. In general, the bill would add a specific real property tax exemption to the District of Columbia Code for the real property of Food and Friends Incorporated, located at 219 Riggs Road Northeast. The bill conditions the exemption on ownership of the property by Food and Friends Incorporated and use of the property by Food and Friends or any lessee of the property to provide charitable food distribution or related services. The bill further provides an exemption for 100% of the land of the property. Background information concerning this property and its real property exemption is as follows. The property was previously granted a partial administrative exemption under a provision of the DC Code which conditioned exemption on the use of the property for purposes of public charity with principal impact in the district. 3% of the land was kept in a taxable status due to commercial use. In 2025, Food and Friends requested that the Office of Tax and Revenue grant a full exemption for the property because the commercial use terminated. In accordance with standard practice followed in processing requests for exemption under the public charity provision, OTR requested information concerning the portion of the organization's clients that were district residents. The information provided showed that less than half of its clients were district residents, and so the property did not meet the requirement established by both the exemption statute and the case law that an organization must primarily benefit district residents in order to qualify for an exemption. Emergency and temporary legislation to maintain the partial real property exemption of the property has been enacted, but this legislation expires after a set period, at which point the property will be subject to the removal of the exemption unless it demonstrates that the applicable administrative exemption requirements are satisfied. Thank you for the opportunity to testify. This concludes my testimony. And,
Thank you. And I believe next is
yes,
641.
Correct. Yes, I have. So good afternoon. My name is Basil Fashina. I'm Assistant General Counsel with the OCFO, and I'm pleased to testify for the OCFO on Bill 26-641, the Archdiocese of Washington Parish Real Property Deed Recordation and Transfer Tax Exemption Amendment Act of 2026. The bill generally would provide recordation and transfer tax exemptions for the transfer of specified parish properties currently owned by the Roman Catholic Archbishop of Washington, a corporation sole, to named nonprofit corporations organized to hold the real property of that parish. These corporations were generally created during 2023 and did not exist prior to that time. The bill would also provide a carryover of the existing real property tax exemptions of these properties to the new ownership. Emergency and temporary legislation covering these subjects has been enacted. The bill would supplant the existing administrative exemption process that ordinarily would apply to transfers from one property owner to another. The Archdiocese has already transferred certain parish properties to these recently organized parish corporations, and the Office of Tax and Revenue has exempted the properties for which properly completed applications have been submitted. The current process has functioned effectively to date, and it appears that the existing administrative exemption framework could continue to serve as an efficient approach for the remaining Archdiocese parish properties as they transition to ownership by the parish corporations. The bill also provides that the Archdiocese may transfer the specified properties to the separate parish corporations through supplemental deeds without transfer and recordation tax. Since other provisions of the bill already exempt the transfer of these properties from the Archdiocese to the parish corporations, this provision does not affect the tax treatment of these deeds and serves no recordation or transfer tax purpose. This provision can be removed from the bill without adverse tax consequences to the Archdiocese or the parish corporations. This provision, however, has occasioned a disagreement between OTR and the Archdiocese, which is extraneous to the tax issues implicated by these property transfers. It has been established under case law for many years that a supplemental deed under the recordation and transfer tax laws does not include a deed transferring property from one legal entity to another. In fact, the District of Columbia Court of Appeals has recently issued a decision which has reaffirmed this point, holding that a deed which transfers ownership of real property from one legal entity to another is not a supplemental deed. Accordingly, the transfer of these properties by the Archdiocese to the separately organized parish corporations are not supplemental deeds, and the language of the bill does not change the established definition of this term. If it is desired to treat these deeds as supplemental for purposes of these transfers, the bill language should be amended to say this expressly. Suggested language to accomplish this change is attached to my testimony. Thank you for the opportunity to testify. This concludes my testimony on this bill. And the next bill is Bill 26686, Alpha Omega. I will move on to that one. Okay, good. So I'm pleased to testify for the OCFO on Bill 26686, the Alpha Omega Social Action and Scholarship Foundation Real Property Tax Exemption Act of 2026. In general, the bill would add a specific real property tax exemption to the District of Columbia Code for the real property of the Alpha Omega Social Action and Scholarship Foundation located at 1231 Harvard Street Northwest. And the bill conditions the exemption on ownership of the property by the foundation and use for its charitable and educational purposes, and that the property not be used for commercial purposes. By way of background, this property has not previously qualified for an exemption from real property tax. Indeed, an application filed by the foundation was denied by the Office of Tax and Revenue for failure to satisfy the applicable exemption requirements. The foundation appealed the denial to the Superior Court, and after a trial on the merits, the Superior Court sustained the denial of exemption. The evidence presented at the trial indicated that the property's character was that of a fraternity house or private club. The property accordingly does not qualify for a property tax exemption of the type administered by OTR. As a result, this property can only be exempted by specific legislation. The bill also forgives all real property taxes, interest, and other related charges assessed against the property for the period between October 1, 2018 and September 30, 2026, and directs that any payments of real property tax be refunded to the person who made the payments no later than 45 days after the effective date of enactment. It should be noted that the forgiveness provision covers provisions before the foundation became the owner of the property, as it is shown by the deed of title to the foundation, which was recorded on October 27, 2020. Furthermore, the bill does not address the outstanding recordation tax liability that has been incurred with respect to this deed. Thank you for the opportunity to testify. This concludes my testimony. And so, just.
We're getting close.
Yes,
26-7.
last one. Thank you for the opportunity to testify for the OCFO on Bill 26700, the Reservoir District Tax Exemption Amendment Act of 2026. This bill amends an existing abatement for the Reservoir District development consisting of specified lots 809, 810, 814, 815, and square 3128 that is currently provided under DC Code Section 47-4683. This abatement will apply beginning in tax year 2030. In general, the bill would amend the affordable housing requirements of the abatement law, providing for a set-aside of 1/3 of the operating rental units in the property as affordable, as defined under specified provision of the U.S. Internal Revenue Code. The units designated as affordable will be available to households qualifying for the 80% income limit category of the multifamily tax subsidy project income limits for the Washington, Arlington, Alexandria, DC, Maryland, Virginia, HUD Metro Fair Market rent area as reported annually by the U.S. Department of Housing and Urban Development, and made in a manner consistent with the specified provision of the Internal Revenue Code. That concludes my testimony on this bill. Thank you very much.
Give me just a second. So we're gonna have 10-minute rounds, but I'm gonna be a little bit longer than 10 because I've got 8 bills that I have to, or 10 bills that I have to ask about. Thank you, everyone, for your testimony. I'm gonna struggle through this on, see if I can do this in bill order. With Bill 26-252, I don't know if I'm gonna have all my questions. That's a problem. It sounds like, Mr. McCune, that your office generally does not see problems with the bill, is even supportive with some of the provisions.
Yes, we're in support of the bill. We think that the bill will permit more accurate assessments because we will have the latest income and expense information that is actually from the prior calendar year versus 2 prior calendar years.
What about the testimony that the assessors do not use the I&E statements, that they use the computer-assisted mass appraisal system?
The I&E statements are used to calibrate the computer-assisted mass appraisal system. It's the data that goes into the computer modeling.
So I was a little surprised when I heard that testimony earlier. I would have thought that the commercial properties, especially the largest ones, because there aren't that many, would be assessed on an individual basis, that is, looking at the I&E statement. But there's instead a computer-assisted mass appraisal?
Right.
Say more?
There's the income from like specific types of properties is aggregated, analyzed and aggregated so that maybe a uniform rent is derived, and that is used to determine what the assessed value of the property would be based on an income modeling. But it's all based on the data that is extracted from the income and expense forms. The income and expense forms are, whether it's computer modeling or individual appraisals, the income and expense forms are mission critical to creating accurate assessments.
So there was testimony that Arlington has a much better computer software for its mass appraisal. Why would that be? That may not be an easy question to answer. Do you know how current the I&E forms are for Arlington when they calibrate their CAMA?
No, I do not know what data they use in Arlington for when they come up with their latest assessments.
Has OCFO looked at the appeal rate in other jurisdictions? Because the appeal rate would reflect the extent to which taxpayers believe that the assessments are unfair. I get it that some taxpayers are always going to think their assessments are unfair, but you're going to get more if more people think it's really unfair.
True. I think it's probably fairly accurate. I mean, and others in this room who are tax representatives could chime in or voice their opinion on this. But I think major commercial properties routinely appeal their assessments year after year, regardless. So I think it's basically a cottage industry of appeals that occur systematically. And I don't know if it's tied, I don't believe that it's necessarily tied to how accurate the assessment is. I think the appeals are going to occur regardless.
Are the appeals successful? My impression is a lot of them are. That would suggest that would support the argument that if the assessments were It would suggest that either the, whoever's granting the appeals, which is probably RIPTAC, is just being generous and just granting appeals, or it would suggest that the assessments could be better.
The, so this is going a little bit beyond the scope of the bill. How many assessments are reduced at the first level appeal at OTR and how many are reduced at RIPTAC at the second level? I don't think that those are high percentages. I think that those are largely sustained. I'm sure Mr. Cooper could pipe in on that, but I don't believe that you're getting substantial en masse reductions that are occurring at RIPTAC nor at OTR. Where they generally occur is probably at Superior Court with the ultimate appeal to of the RIPTAC decision to Superior Court. By way of analogy, we have about 900 appeals that are lodged at Superior Court for major commercial properties generally every year. The Superior Court decides one case every 2 years. And then that's an approximation. The rest of the 899 and a half cases, we have to settle. So I think you can understand what probably occurs during settlement negotiations.
You're not suggesting that the government settles a case that they think they could win, because that's revenue that we lose.
What I'm suggesting is that we have intense pressure from the Superior Court to settle cases because they're not going to decide them. They don't have the means to decide the cases timely. One case every approximately 2 years gets decided. We'd like to have more decisions. We don't. If you go to Maryland, they have an appeal structure that's based pretty much, I think, solely for real property assessments. I think Virginia probably does too. We don't. So these get backed up in Superior Court, and that's where they linger. And what happens is we have show cause orders that say, why aren't you settling? Get this case out of here. And there's a lot of pressure that comes from the judicial side to eliminate the docket.
I could pursue that further, but I will not. There was testimony that criticized the 2 separate assessment and appeals calendars. 2 different calendars may create unnecessary administrative complexity for property owners. What's your reaction to that, and what do other jurisdictions do?
I'm assuming that most jurisdictions probably have everything on a uniform assessment time. You know, all assessment notices go out at the same time, presumably. For us, the 2-track system, I don't think would be confusing, because for homeowners, they would remain on the normal cycle. And it's only that major commercial property owners and apartment building owners that have to file income and expense statements, they would be on the more delayed notice system. And they would know that through a published, we would publish like which properties are on that second track. So I don't know that it would be all that confusing to commercial property owners. Everyone else is going to be staying the same. The homeowners or whatever, they won't have to look. It's just the major commercial property owners and apartment building owners that would migrate to the second track. They're generally more sophisticated, property owners that monitor these activities, and for sure their tax representatives would be.
Let me ask Mr. Cooper. I should have asked this a minute ago. So What is the rate of sustaining or of granting appeals?
Great question, Mr. Chairman. Approximately 93% of all the cases that come before and are heard and decided by the commission are in fact sustained. Remember, the burden is on the petitioner to prove error on the part of the Office of Tax and Revenue. There's a presumption that the OTR assessment is in fact correct. So 93% of all the cases that come before us are sustained: commercial, residential, industrial, bare land, you name it. 6% of all the cases that come before us were reduced. Now that 6% may say, well, that's a lot that the RIPTAC is doing these reductions. Well, that 6% also includes where there was a recommendation by the Office of Tax and Revenue for us to make the reduction. There's a process to do that where they say, look, we can't change it in our system because it's now before you, which, you know, you could have a debate on that. But they said, we cannot change the number. So we recommend you change the number, and we can support that change. We've done our additional research. We've looked at new I&Es, what have you. And then now if the petitioner says, thank you for your reduction offer, but we don't accept it, we think it should be another 80%, another 20% reduction, then so long as it met that 5% threshold, we will accept the recommendation from Office of Tax and Revenue for the reduction, because again, the presumption is their assessment is in fact correct. They've got the manpower, the expertise, the CAM, all of the data software. They can make those decisions. The other are stipulations, where in fact Office of Tax and Revenue says we recommend a reduction of 15%. The petitioner may have had a appeal for 45%, but they say, you know what, we'll accept your 15% reduction. That's called a stipulation. They then sign a document. We then adopt that, and the reduction goes into place. So the 6% of all the cases that become before us, a majority of them are by stipulation and recommendation. Now, there are other cases in which we find error on the part of Office of Tax and Revenue, where they either disregarded information that was obvious, that was presented, that they had, either they just disregarded it or they applied the wrong statute or something on that line. And we do address those routinely and make reductions, as again, so long as the reduction is greater than 5%. And of course, the Chairman Mendelson, we also handle matters from the Department of Buildings, which includes vacant, blighted property and the like. And so we also address those. And again, the presumption is that both Department of Buildings and Office of Tax and Revenue, that their determinations are in fact correct, that proper notices were sent and the like. And then we adopt 93% of the time what the Office of Tax and Revenue with their expertise says is in fact correct. But again, we do an analysis, we listen to all the testimony and evidence, which is given on the record, and then we make our decision. But again, the presumption is that OTR, with all of their data and software, is correct.
93% of the cases you sustain the assessor.
Correct.
6% you reduce the assessment.
6%.
Is there any significance to the 1%?
It could be where cases are withdrawn, or again, that it could be, 99.3% fit those numbers. Again, there are cases that get withdrawn often, so that goes into the total number of cases that came before us where we didn't resolve it at all.
Let me ask you, Mr. Cooper, the bill, gosh, I have so much paper here. The bill changes deadlines for various things to happen.
Yes.
As I understand it, for residential, like homeowners, there's no change in the calendar. I'm looking at Mr. McEwen. That's correct. There's no change for residential homeowners in terms of the calendar.
That's correct.
So for commercial, the I&E is due April 15th, not March 15th. And assessment notices are sent by June 1st, not March 1st. And the appeal process would be extended by 15 days on both ends. And I don't know what that means since I don't see that in front of me. So when is, Mr. McCune, when is RIP-TAC supposed to be done? By February 1st, by February 15th?
Currently, it's February 1st, and under the bill, it would be February 15th.
Okay. But RIP-TAC is also supposed to complete cases within 80 days. Did I remember that correctly?
Yes. I'm sorry, was that directed towards me? Yes, we have 80 days to correct, produce a decision on a residential 5 or greater or commercial properties. And 83% of all of those cases were in fact decided within the 80 days this past year.
Okay, so the testimony has generally been that RIP-TAC doesn't meet the February 1st deadline. Well, why are you still hearing cases in March? If you have 80 days, they have to be filed by some date in September?
Yes.
Well, why are you still hearing cases in March?
Well,
and how does that fit within the 80 days? Or is it 80 days after you hear the case?
We have about 6,000 cases. We have 6 full-time commissioners, we have up to 8 part-time commissioners. We have only 2 full-time administrative staff to have to receive all the documents, review them, prep them, organize them, schedule them, and then we have to hear the cases. And so we have 2 panels going each day, 5 days a week. And we have sometimes 30 cases. It would run from different properties. We run from 10 o'clock in the morning until 5 o'clock and later, sometimes in the afternoon.
So let me interrupt you.
Nonstop.
When's the 80 days calculated from? When does it begin?
Yes, sir. I apologize. Yes, 80 days begins from the date of the hearing. So when we have the hearing, we have 80 days to issue a decision.
Okay.
And we have, I'm sorry,
right
we
now,
have hearings every day.
Right now, the deadline for filing an appeal is when?
I believe it's September, or it's X number of days. So this
September
poses another
30.
issue. It's supposed to be X
30.
number of days after the decision on this first level appeal is rendered by OTR. There have been instances where that was late, and so therefore the decision, the appeal was late. Sometimes when they file the appeal, certain documents aren't available yet. They can't file an appeal unless they've received the decision from OTR on the first level appeal. And so there are reasons why cases are still scheduled in January and in February. Some cases get rescheduled. Sometimes the petitioner may be ill. The cases get pushed off and have to be rescheduled. So we're here this year. We heard cases into March.
Who formulates your budget and who is responsible for your budget?
Our executive director, in conjunction with our chairman, Mr. Trent Williams.
So did they reach out to the council when we had the budget to say we need more resources?
It is my understanding, I wasn't involved in those, but it's my understanding that for the last several years have been a request for additional resources. I can't.
And to whom was that request made?
I would presume to the council, sir, but I'm not sure. I wasn't involved in that, but I know that there were internal discussions about the need for additional staff. We've got only 2 full-time administrative staff persons who are overloaded, and 1 full-time IT expert who handles all the hearings, bouncing back and forth between the panels. Now, all the petitioners in the room, the stakeholders, they know that our staff works hard. But
So I'm not questioning that, but I will just note that the committee I chair has oversight over OCFO and RIPTAC, and I don't remember any testimony at our hearing with regard to RIPTAC, our budget hearing with regard to RIPTAC and resources. I'm also the one who has to put together the proposed budget committee print for the council, which I did on June 8th, maybe. And I don't remember any outreach from RIPTAC with regard to the need for resources. In fairness, I do recall testimony about this at the confirmation hearing for several members.
Yes.
But not in connection with the budget hearing or putting together the committee print. I have more questions, but I'm going to turn to my colleague for 10 minutes, Councilmember Bonds.
Thank you very much, Chairman, and thank you all for being here, and thank you for your testimony. I have a couple of questions. I wanted to ask Mr. Cooper, when did the number of cases that your commission is seeing escalate? Has it been in recent years, the last 2 years, 1 year, 5
Well,
years? What?
yes, good question. I used to be chairman when it was the Board of Real Properties Assessments and Appeals, and I came back as a glutton for punishment. But over the years, in 2022, there was nearly 7,400 cases. And this is, coming out of the pandemic, where there was a lot of reductions in valuations, tenant occupancies. The number case workload was slowly reduced down, and then it's come back on the rise again. This last year, we had almost 6,800 cases. So there were similar numbers years ago, but not that great. Because in fact, the hearings were held in person. And as some of the stakeholders would know, those hearing rooms got really warm sometimes, and they would have to bring down boxes and boxes of documents. So having it electronic and submitted and remote hearings has helped tremendously, but that also may be a feed into the fact that we're actually hearing more cases now.
Yes, thank you for that. Once upon a time, RIPTAC was in my committee, the committee that I chaired, and I did not remember or recall that there were a tremendous number of cases at that time. So I was curious as to when the escalation came. So let me just ask you, what is the frequency of in-person assessments on commercial properties, as an example? And maybe that's for Mr. McEwen. I don't know. What I'm getting at, how informed, how are you informed about the assessment appeal process? Do you hear back from RIPTAC? I understand that your office will submit to RIPTAC your opinions or your recommendation as to how they should move forward for any appeals that they receive. And so I'm trying to understand in that process, is there, what is your recommendation, sort of ironclad? Because I'm trying to figure out how we reduce the number of appeals, because either we reduce the number of appeals that Mr. Cooper's office sees, or we be a little more accurate in the public's perspective for the number of appeals that we do. So I'm trying to understand that. I've got 3 ideas pulled together.
As far as with RIPTAC, they give a hearing notice. Our appraisers attend the hearing with the tax reps for the property owner, and then ultimately RIPTAC issues a decision, and they send the decision to us and to the property owner. So that's basically how that's communicated. as far as, more accurate assessments are always the main, is always what we're supposed to strive for. Are those necessarily going to reduce appeals? Maybe for property owners, homeowners. I don't know that it will for major commercial properties because they basically all appeal 100% every year. So I think that's why they want their LOA, the letter of agent authorization, to be good for 3 years because they're just going to keep using it.
And would you say that knowing the commercial community is going to appeal and they understand the logjam that we have in the courts, that they're likely through a settlement to win? I guess it really doesn't matter about the number because we know they're going to appeal anyway.
Well, winning is hard characterization, especially when it comes to appeal assessments. There is with assessments, there's always a band of acceptability of what a property is likely to sell for, what its value is. Nobody can fully predict with 100% accuracy, but there is normally like maybe a band that can fluctuate maybe by even 10% or something like that. But
So how do you do a settlement then? What do you look at in order to settle? Are the numbers, the settlement numbers, closer to what the property owner wants? Or is there some guide that we have generated through a computer model that says whatever? Or is it through, have we done in-person assessments of the property? Would that help? I'm just trying to understand how we hold on to the money that we collect, and what is it based on? If it's based on, good policy, then we want to hold on to it. If it's because we are not doing in-person assessments and maybe we missed something, that's another story.
by the time litigation's going on, there's a lot of information going back and forth about the specific property characteristics. So I think those are becoming very fine-tuned at that point. Like I said, there's always a band of acceptability of where an assessment could lie. I do believe that if we had more final decisions from the ultimate appeal process, that that could serve to reduce the numbers of appeals as well. Right now, like I said, we're not really getting decisions. And when we get decisions, we learn from those. So like, when a judge says, no, this is the law and this is how it's going to be interpreted and how you're going to apply it. We learn from that, and then we take that forward on other assessments. So the entire appeal process is instrumental to us for deriving better assessments. But it would be beneficial if we actually could arrive at a ultimate decision.
I hear you. Thank you so much for that. Thank you. And I want to thank you all for your comments on some of the other properties and your analysis. I say, go forward. I like what I'm hearing from you, Mr. Chairman. I think that they make a lot of sense. Everyone who is involved in the nonprofit world would like to have permanent tax exemption irrespective of what they may actually be doing and how they do it. But, that's not, we're not in a perfect world, I don't think. And so we just have to look more closely at some of the organizations that are classified as not-for-profit and how we treat them. So I'm hoping there'll be more conversations with you about it. Thank you so very much. Thank you. Thank you, Mr. Cooper. Thank you. Thank you,
Now,
Chairman.
Councilmember Bond, if I may just touch upon one thing that you said earlier. This is Robert Cooper again.
Yes.
One of the issues, and I think the testimony about this, it goes back, the use of the income and expense forms. The fine tuning that was just discussed, which then leads potentially to settlements in the court. We see that too at our level when Office of Tax Revenue has the benefit of the full complement of documents, and that they're able to have that conversation. And I think that was maybe where the gist of this legislation is to get those income and expense forms before the parties, and they have these discussions. Because a lot of the cases that come before us, other than capitalization rate, are, what are the actual numbers? So you may have this mass appraisal viewpoint to get the appraisals out the door in a timely fashion. But then when someone appeals or entity appeals, then they kind of narrow down and get a look at these actual numbers as what was just being said about, what is the true value of the property? What are you actually making on the property? Because we've seen sometimes, they're saying, well, the average rents are this. Well, that those rents are not being achieved at this building. So because this building is before us at RIPTAC, and likewise, that building is before that judge in that court, they're saying, well, I don't necessarily care about your mass appraisal. We're now focusing on this appeal that's before us. And have you looked at these numbers? And once they look at those numbers, then they're able to have probably a better conversation, which actually gets closer to the true value of the property. And I know I'm not here on the senior things, but clearly we have cases that come before us that relate to the senior issues, and we have to resolve them. The laws are what they are. Case law is what it is. But I have to say, if you've got in our community, we often don't use wills and trusts. People put their children's name on their properties as a means of asset retention in the family, passing down generational wealth. But if the one senior is living in the property and a child is on the deed with her, and they're joint tenants, that's a question that came up a couple years ago. Well, now they're joint tenants. There is no division of ownership. There is no 50%. Both own 100%. So how is that viewed? Those cases have come up, and we've had to, despite our personal feelings of tax reform, says, well, no, you view it as a less than 50% ownership. Well, how is that when under the law of property ownership, they both are owners jointly? Why shouldn't they now own 100%? They just own it together. There's no 50%. Tenants in common, you might have 51% and the other owns 49%, but not when it's joint. And so I think there needs to be some clarification. If it hasn't already been made, I think that also needs to be addressed.
I thank you very much for your comments, Mr. Cooper. And again, I thank the entire panel. And I am hoping that this hearing points to the need for reform. And I think we need to be as a little more accurate as to the times in which we are living. We're not back in the 1940s or 50s or whatever, whenever we began this process, maybe even before, for the District of Columbia. And we just really need to look at where we're going and how we're going to treat our dear community, District of Columbia. And Mr. Cooper, I especially want you to have an opportunity to talk to the seniors. You know, they're in my committee also. So
Yes.
I want to arrange that, so know that. And I think I should have tax and revenue also to come and talk, because so many young people think that they know how to advise, but they really don't. And thank you, Chairman. And I know I've gone over my time, but I must say, this is a very important hearing, because it gives the community an opportunity to hear from our so-called tax collectors, because that's what this is about. So thank you very, very much.
Thank you. I have a few more questions. I'm going to go through the remainder of the bills. With regard to the Senior Citizen Tax Aggregation Amendment Act, Bill 26-360, if I'm understanding correctly, Mr. McEwen, the way you read the language of the introduced version, a senior citizen could own, you said, a small interest. It could be like a fraction.
Yes, that's correct.
Mr. Fashina. So you suggest language where it would be clear that the taxpayers in the aggregate would be over 50%.
That's true. I proposed language that if you want to aggregate the interest of the seniors who are living in the property and have them own at least 50% of the property, then I've suggested.
That's what the language gets at.
That's right. Yeah.
Okay, and then with regard to Bill 26-476, so that's you, Mr. McEwen. Again, your concern is just in the drafting here, if the council wants to go forward. But what isn't clear to me is what you're correcting with the proposed language.
It mainly had to do with a surviving spouse of a veteran who, let me see. I think a surviving spouse of a veteran who died in the line of duty. When you read what's in the current draft versus what I think they were trying to do, it seems like there wasn't much of a distinction between what happens when you have a veteran who has a 100% disability service incurred condition that's 100% disabled. And then down in paragraph 5, when the veteran, the surviving spouse of a veteran who died in the line of duty, when I read paragraph 5, it starts talking about the dwelling unit was owned by the veteran at the time of the individual's death, or I guess the veteran's death. The dwelling unit was acquired by a surviving spouse within 2 years. I think what they're trying to get at was the surviving spouse buys another property in 2 years and not acquires the veteran's property in 2 years, because if they're the spouse, then they probably was jointly owned, and she wouldn't have to acquire it, or I say she or he. The survivor would just come to own the property because of joint ownership or tenants by the entirety. So when you talk about acquiring the property within 2 years, I think they're talking about acquiring a different property. And not staying in the same one.
And so that's what you were focused on, was trying to clarify that.
Yeah.
Okay, let me move on. 26-484. Are you in your testimony objecting to the idea of the letter of whatever it is, letter of authorization, letter of agent of authorization being multi-year, or are you objecting to the code citation that's being amended?
It's more, I don't believe that they should be amending the Uniform Act related to powers of attorney. I think what they're trying to do is create a
The ability to have a LOA for a tax case.
yeah, for real property tax matters.
So the bill is drafted as you see it amends the wrong law.
Very
Amends-
expensive, yeah.
And if it amends the correct law, it's up to us whether we want that policy, but that's not what your objection is.
Right. I mean, if they wanted to do that, I think it would be helpful if they did it within Chapter 8 of Title 47 related to real property tax matters. If it's going to be multi-year, we're going to have to create a database that can track that, but we don't have that right now. Right now, we get a new
Well,
LOA every year.
What do you do with it? I mean, this strikes me as a lot of paperwork. Why can't I just give you a letter of agent authorization? And every time I show up, obviously within a limited number of years, but every time I show up, I just produce the same letter. So I give the letter to the assessor at the first level, the same letter at the RIPTAC, the same letter the next year. Why wouldn't that be good enough?
But if that's, I mean, to be honest, if that's how it would work, we were thinking that maybe we would have to create a database and have this housed in there and be able to pull on it and know when it expires and things like that. But you're just saying like have them submit the
Yeah, and
LOA.
everybody knows, let's say it's good for 2 years, everybody knows that if I come to you, you're the assessor, and I come to you at first level with a letter that's dated April 1st, 2020, that's out of date. I come to you with a letter dated April 1st, 2026, I can use the same letter in 2027. I mean, I suspect there aren't a whole lot of, what do I want to say, false agents who are spending their time at RIPTAC.
Right. Okay. So for that is like when it comes to major commercial properties, we have the LOA notarized, and you might say that maybe that's a little archaic, but the reason
I don't know that I have a problem with it being notarized, but only once. And maybe they even give you the original so that somebody can track it down, but I'm not sure that I think that Scott Kreider, who probably does a lot of these cases, is showing up under false pretenses in cases.
No, it's just the appraisers are at OTR are very protective of, because the income expense information is part of the case file, and the LOA gets access to that. So they are, let's just say that they're highly protective of income and expense information.
All right, that adds a dimension here. Let me move on. With regard to the 5% rule, what if we kept the 5% rule for, let's say, valuations under $10 million? So then we're talking about more meaningful dollars if it's a more expensive case. Would that create a problem, having a bifurcated approach toward 5%? No, there was testimony that most jurisdictions don't have a 5% rule. So there also was testimony that this could overwhelm RIPTAC, which is already overwhelmed. So if we said 5% for large value cases, 5% for no 5% for large value cases.
Right. I mean, I'd have to defer to RIPTAC on that one. It's also, the only thing I know is the 5% rule, I think, has been around since at least the Board of Equalization, the BER, or maybe prior. But it's kind of part of the DNA.
Yes.
But, I'll let Mr. Cooper on it.
Mr. Cooper, so would that create a problem for RIPTAC if we said that there's no 5% rule for large value cases and only for the smaller ones?
No, I think what would happen is, I mean, again, most of the big properties, the delta between the assessment and what the plaintiffs want or the petitioners want is typically 30%, 40%. So the 5% rule doesn't really come into play until there's a stipulation or a recommendation. And so there have been times when the recommendation was reduce it by X, but it fell within 5%, and the assessor was unable to tweak it to get it beyond 5%. And therefore, even though he said, yes, I recommend a reduction, it wasn't within 5%. We cannot, it was within 5%, where our hands are tied at that point. So yes, it would give some leeway for us to make some minor revisions if the petitioner does not accept it. But I don't know that there are many cases where the petitioner is sitting around saying, well, my request is only, 3%, so I'm not going to file an appeal, because they'll file an appeal and ask for 30%.
Yeah.
And we'll settle for 6% if the recommendation, if they do a stipulation. Or they'll go to court, and then whatever happens there anecdotally will happen.
That's helpful. Electronic communications, so still on Bill 26-484. Mr. McCune, the issue there is again the wrong code citation. You said OTR would suggest council consider making such amendment to 47-804. I'm guessing it was a different
Yes.
statute.
Section 804 has to do with what is acceptable notice under the chapter, and right now it's like first-class mail. So it would be beneficial if that general provision could be tweaked to accommodate what occurs at the first level appeal with OTR and how notices are done at the second level with RIPTAC. I think it would be better that it were in the general provision relating to the OTR notices under for real property tax matters. That's all.
Okay. I'm moving to Bill 26-564, Food and Friends. So the way I read your testimony, this is Mr. Fashina, is it's up to us if we want to grant the, as a matter of policy, the exemption. You go into some of the background why they didn't qualify for the exemption categorically. Do you know what the fiscal impact would be if we make this 100%, which is the bill?
Unfortunately, no, I don't have a fiscal impact statement.
Okay. Okay, but otherwise, the bill in terms of form is acceptable.
Yeah, I don't have any issues with the form.
Let me turn to, I'm going to skip Archdiocese for a second. Alpha Omega, probably the same issue in form. It's okay, but there's probably a fiscal impact, and you don't know what that is.
Correct. I don't know the fiscal impact. I would also suggest that
It shouldn't provide an exemption, retroactive exemption before they own the property.
Yeah, I wouldn't, that doesn't seem, I haven't seen that before.
And 26-700 Reservoir District, there was no issue there.
No.
So let me come back to Archdiocese, and I think that's you, Mr. Fashina. So I'm trying to think, and I don't want to spend a lot of time on this. There's the issue of the tax exemption. I don't think there's any issue whether the Catholic Church should be exempt from paying real property tax.
No, there's several paths to getting the exemptions that they want.
They really, truly resent all the paperwork, and my sense is that OTR is minimizing that, and the Archdiocese is really feeling the pain with 89 properties.
Well,
they also seem to feel strongly that a supplemental deed, there's a lot of meaning there. So am I reading the addendum correctly that they can get their supplemental deed if we just simply deem that the transfer is a supplemental deed?
Yeah, that's what the suggestion would be. Yes, just to treat it or deem it as a supplemental, because I mean, I can go through all the like legal stuff about what is a supplemental deed and, you know, so on, the history and so on and so forth. I don't know if you want to do that.
I don't. But I also, Mr. Gelman's testimony was kind of persuasive on that point. He cited a 1987 case and also noted that the Columbia Realty case was distinguishable.
I don't, if you want to get into like a legal discussion, I respectfully disagree with a number of the things that he said. I don't think Columbia Realty Venture is distinguishable. I think that the factual situation we have here is clearly outside of the supplemental deed rules that have been laid down by the statute and the case law. The the Superior Court case he cited, we think is distinguishable. And also, since it's a Superior Court case, it's not really of precedential effect. But the long and short of it is the bill that they have gives them the recordation and transfer tax exemptions that they're asking for and to carry over the real property tax exemptions that they currently have, all without getting into the whole supplemental deed issues. I have a feeling that there's really no tax purpose to calling these supplemental deeds, given the existing legislation and the other provisions of the bill, and the fact that they could apply for administrative exemptions here. And you know, so it's, as they indicated in their testimony, it seems like they want the supplemental deed to sort of serve some sort of a non-tax purpose. And I think that, you know, supplemental deed concept that they're dealing with here is a tax concept, and it really, you know, really looking outside of to non-tax purposes or trying to make the supplemental deed concept do non-tax work when it is just a tax concept is probably, you know, I think that that's, you know, not really, that's going beyond really what's necessary for purposes of this tax issue.
Well, I could agree with you that it's going beyond what's necessary for purposes of tax.
Mhm.
They're a church.
Mhm.
Last I checked, a very legitimate church, and they're tax exempt.
Yes.
But I heard some testimony that there is meaning to recognizing that the ownership hasn't really changed. That's outside of tax. I think that's why it's such a big issue to them.
Yes, yes. Mhm.
Ms. Rhodes testified to that, but I think Mr. Gelman did as well. That, and I can be sympathetic to that. I mean, I've owned my home for 2 centuries, and I just, there's some, there may be some, not no, I've not actually owned my home for 2 centuries. There could be some not easily identifiable reason why I don't want the record to suggest that the ownership has changed.
Okay, well, that's certainly a legitimate point, but what they're trying to accomplish, or the way they're trying to get there, is by using a tax concept and tax language and a tax exemption that has an established tax meaning.
Yeah, but deed is not necessarily tax. Now, I'm going to get over my skis very quickly, but because I'm not an attorney, but
Yeah.
I mean, a deed is more, it's something different than tax.
No, well, for purposes of the transfer and recordation tax, there is a definition of a deed.
Sure.
Yes. And that's my concern with this, is they're using concepts and terms under the transfer and recordation tax statutes. And supplemental deed is defined in the recordation tax statute as a deed that simply corrects or confirms a prior deed. It does not reflect a transfer of property from one legal entity to another.
That's in the recordation tax law.
That is, yes.
Okay,
that's in the
but I'm guessing there's a whole lot of case law around supplemental deeds?
Not that I'm not outside of the tax context. I'm not really familiar with any, and they really have not cited anything outside of the tax context on that. So I mean, you know, you could make the argument outside of the tax context that, well, you know, the circumstances are such that this is not really a change of ownership. But if you're trying to do that within the context of the tax law, you have to follow the tax definitions of the terms. You have to follow the tax rules, the tax the tax concepts. And the basic transaction we're dealing with here is a transfer from the Archbishop of Washington, Corporation Sole, which is the legal entity that represents the Catholic Church in the District of Columbia, to a newly organized District of Columbia nonprofit corporation that is going to hold the property of each parish. They've got like 30 plus of these nonprofit corporations they organized back in 2023. And what they're doing is they're transferring a deed from the Archbishop to the parish corporation, which is a separate legal entity. And under the clear case law, Columbia Realty Venture, and the other case, the Court of Appeals just decided, reaffirmed this within the last month, that a transfer of property from one legal entity, that is a corporation sole, to another legal entity, which is a DC nonprofit corporation, is not a supplemental deed. It's a transfer of ownership from one entity to another. Now, they can make arguments and say, well, these parishes, they go back 100 years and, all this and that. For recordation and transfer tax purposes, we don't have to look at any of that. The only things we are concerned with is who are the parties to this transfer, the corporation sole and the DC nonprofit corporation. Whatever happens outside of that, behind that, that's not a tax concern for us. And we don't need to get into that to decide the tax issue. Now, if they want to go to some other agency and say, well, really the this parish corporation, which is an unincorporated entity and is not recognized for civil law purposes, well, it really was the owner of this church. And so, we're putting it into this new corporation, which is just holding title. It's it's all the same thing. They can certainly make that argument, but they can't use the tax law to prove that there's no change in the ownership. They'd have to prove that under whatever law would be applicable to the agency that they're addressing. And that's kind of our main concern with this, is just that we want to keep, the tax law, the tax law. And we also don't want the meaning of these terms fuzzed up so that we would have problems applying the tax law in other contexts. So if they want to, go to some other agency and say, well, we're really not changing the ownership, they're not going to be able to say, I don't think they should be able to say, hey, oh, and OTR agrees with us, so you should do the same thing that OTR does. I mean, I don't think that's the right way to approach this. So.
Right. I think you're going a little bit beyond, though, the addendum that you offered. And I do want to, so I've not gotten a reaction from the Archdiocese on the addendum, but I do think it's constructive that you've offered some language that might solve the problem. I will reiterate, I think the problem is multifold. It's one, they want the tax exemption. And they did get, in the middle of all this, they did get a bill for 4 properties. The second is that they want to avoid all the paperwork. And the third is that there are, how do I want to put this, intangible benefits or some unrecognized benefits from maintaining that the ownership isn't really changing. So that's what we're looking to try to do here. I'm going to leave it at that. Thank you, each of you, for your testimony. Okay, I'm going to wind down this hearing. Again, thank you to all the witnesses, not just the government witnesses who are here at the moment. As I indicated before, the record in this matter will close at 5 p.m. on Friday, July 24th, 2026. So if anybody wants to submit anything else for the record, and there were a couple of people who owe us their written statements, they have 2 weeks to do so. This has been a hearing on 10 different tax-related bills. The time is 2:35 p.m. and this hearing is adjourned.